Oh, wow. Just me all by myself. I don't see anybody in chat. Okay. That's fine. That works. So I guess I don't have to say hello. Welcome to day 25 of the Michelle Troconis trial. But here we are, day 25. Bye, Franz. First. Yeah, well, I beat you in here. So what does that say? Yeah, what? So we're going to get started on day 25 here. Getting the Rumble link up for everybody who wants it over on Rumble. Third, yes, hi. Hi, Spooky Wife. Hi, Dream. Hi, Dreamer. Turnips. What are we going to give this one? All right. Okay, so what else, guys? So we're going to fire this up then. We're going to have to get this going a little bit fast speed just to make sure we get through it because we do have a couple days to catch up on, but I don't think it's going to be too insurmountable. Here, let's see. The lives. Day 25 in the morning. Okay. So this already starts mid motion practice by Michelle's attorney. So I don't know what they're talking about first. I don't really know what this is about. We'll find out pretty quick, though.
Giving a client telephone numbers, et cetera, is not covered by the privilege, as well as if it doesn't go into the substance of the representation, it is not covered under cases such as State versus Davis. The code of course, talks about back and forth, so it's reciprocal communications between the defendant and his lawyer and vice versa. And the purpose is to encourage frank disclosure by client to lawyer without the fear of subsequent disclosure. And I can agree that the fact that the individual, in this case, Mr. Dulos, is deceased, does not in any way waive the privilege any more than a psychiatric privilege is waived by the death of the patient in that case. So I'm not sure what the extent is of the concern regarding the testimony. Mr. Rose, Attorney Rose, is not testifying today. He's not scheduled to testify today. And he's going to only be testifying the events time-wise surrounding the production and the review of certain documents, particularly the Dr. Herman report by Mr. Dulos and Mr. Rose. Without getting into their communications, Your Honor, recall that Attorney Meehan was called by the state, and he was allowed to testify to certain reactions, certain comments made in his presence with Mr. Rose present. So I'm just going to indicate that to the extent that that matter is going to be covered, it's no further. It's the same limitations as was presented with Attorney Meehan and his testimony. I also want to correct one statement. I'm not sure that Attorney Jennings was aware. The family court matter, the only thing that was sealed was the two court appearances on May 14th and May 17th, 2019, and the transcript and the discussion of what happened there, as well as the sealing of the report, Dr. Herman's report. Everything else remains, well, unless it's been destroyed by now, but remain in the public record. I was able to get a complete copy of documents from the court clerk's office of every pleading going back. Other transcripts were available, had been prepared and disseminated. So I'm aware of the court's restrictions. I had no intention of going to that. I have no intention of going to any of the substance of communications between Attorney Rose and Mr. Dulos. And of course, that would not cover communications that Mr. Rose had with my client, which I intend to elicit to a small degree. There were communications with my client directly by Attorney Rose. So I think that based on that, that should eliminate any concern raised by Mr. Jennings. And I would note when I presented what I intended to get into with Mr. Ment, he also agreed with me that he did not see that that would fall within the purview, but to be safe, he wanted to make sure that the court understood that the privilege was still in effect. And I fully, not only do I accept that, I fully agree with that as an important concept.
Thank you. The court is not inclined to grant the motion to quash. What the court will require, though, Attorney Jennings, you may approach the podium. The motion requests that this court issue an order quashing the defendant's subpoena or otherwise limiting the scope of any compelled testimony through an appropriately tailored protective order. The court would require a protective order drafted by your office to be considered. It is not the court's role to draft its own protective order on behalf of any party. So if that can be filed today, the court will take that up probably tomorrow. The court does not know when Attorney Rose is scheduled to testify, but the court will consider taking up a protective order, which the court may grant, deny, or modify. And that should be filed by the close of business today.
Yes, Your Honor, and I will speak with defense counsel. I know my partner, Mr. Ment, already has, and try to tailor any protective order to the contents that counsel seeks to elicit from Mr. Rose.
Thank you.
Thank you, sir.
We are still 10 minutes ahead of schedule, so we'll take our 10-minute break until 10 o'clock, and then we'll start the proceeding. Thank you.
All right.
So we talked about this the last time they were in court. Oh, American Dreamer for $2. Thank you. Saying appreciate you more than $2. Match anyone, please. Well, thank you very much. So it looks like there was an issue when last time we talked about this, with the subpoena being issued and whether or not it was going to be quashed and fighting it. Sounds like that attorney brought his attorney, and looks like they're working out the problem here. But we are going to do a little time traveling because there's a bit of a break.
Ladies and gentlemen, we continue with the state case.
Yes, Your Honor. The state would call Gloria Farber to the stand, please.
This is Jennifer's mom, Gloria Farber. Jennifer Dulos' maiden name was Farber.
Please raise your right hand. Mrs. Farber, if you wouldn't mind taking a look at the clerk. Thank you.
Right hand, please. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I solemnly swear to tell the truth, whole truth, and nothing but the truth. This is so help me God.
Thank you. You could state your name and then spell it for the record,
Gloria Farber.
and spell it.
Pardon?
You could spell your name.
Gloria. F like Frank. Arber.
Thank you.
Ms. Farber, you may be seated.
Good morning, Mrs. Farber. How are you?
Fine, thank you.
Mrs. Farber, may I call you Gloria?
Yes, please.
Okay, thank you. Gloria, how are you related to Jennifer Farber?
She was my daughter,
How old are you, Gloria, if you don't mind my asking?
88.
And where do you live?
I live in New York City.
When was your daughter's Jennifer Farber?
Yes,
Okay, when was Jennifer born?
she was born September 27, 1968.
How many children did Jennifer have?
5.
And what are their names?
Petros, Theodore, Christian, Constantine, and Noah.
How old was Jennifer in May of 2019?
50.
Now, in the time before May 24th, 2019, did you see your daughter often?
Yes,
Did you speak to her often?
yes,
Did you see your grandchildren often?
yes,
Now, on May 24th of 2019, did you have plans to see Jennifer?
yes, I did.
What were those plans?
Well, she was going to meet us at my apartment
Is that in the city?
in the city, in New York City.
And were the children coming as well?
Yes, they were.
And did the children show up at your apartment that day?
Yes, they did.
Who brought them?
Lauren Almeida.
Now, was Jennifer supposed to come to your apartment to meet you and the children there?
Yes,
Did Jennifer show up at your apartment that day?
no,
Have you seen your daughter Jennifer since she failed to meet you at your apartment in New York City on May 24th, 2019?
No.
Have you spoken to her on the phone since that
no, I
day?
have not.
Have you gotten any emails or text messages or any communication from your daughter since that
No.
day? I'm sorry, you have to speak up. quick.
No,
Okay, thank you. And Jennifer's 5 children, when was the oldest one born?
April 20th, 2006. By 4 minutes, because they're twins. So
Oh.
the oldest one is Petros. So there's 4 minutes apart
So-
between Petros and Theodore.
So the oldest by 4 minutes?
Yes,
Okay, in 2006?
yes,
Between 2006 and 2019, did Jennifer ever miss one of her children's birthdays?
never.
And the children celebrate their name days, right, under the Greek culture?
Yes, they did.
Did Jennifer ever miss a name day between 2006 and 2019?
Yes,
Was she always there for them?
pardon?
Was Jennifer always there for them?
Yes, she was always there.
And as of now, 2024, do you have custody of the 5 children?
I do.
And since May 24th, 2019, have any of the children ever seen or spoken to their mother?
No.
I have nothing further. Thank you.
You're welcome.
Good morning, Mrs. Farber.
Good morning.
I just have a few questions for you, if I may. Can you hear me okay?
I do.
Was Jennifer's plan to come to New York by herself or with the children?
By herself, but she dropped the children off at the New Canaan Country Day School.
And the children did come with Lauren to New York that day to your
Yes.
apartment?
Yes,
Were they there at about 12 or 1 in the afternoon?
I'd say about 12 or 1, yes.
Did you reach out by telephone to Jennifer the day before she came to New York?
Objection.
Brown,
Outside the scope, Your Honor.
it is outside of the scope.
Well, it's a preliminary to the plans of her coming to New York.
Well, the objection is sustained, but you can continue with the line of questioning.
Did you make plans with Jennifer to have her come to New York the next day? Did she share that with you?
Yes, she did.
Did she mention she was first going to a doctor's appointment that morning?
Objection, Your Honor.
Well, the court allowed the question concerning plans, and so this is a follow-up on plans. Overruled.
Do you remember the question, ma'am?
Did she have plans to visit a doctor?
Before she came to your apartment?
Yes,
Do you remember if it was a Dr. Geronimus that she was going to see? that morning?
yes,
And did you, as part of your making plans with her, did you try to call her the day before to confirm those plans in the afternoon?
Objection, Your Honor.
Well, now the line of questioning goes from what was the plan to try to confirm the plan. And so the court is going to sustain the objection.
Did you speak at all to Jennifer that morning of the 24th?
No.
Did you call her on her cell phone?
No.
Objection, Your Honor.
Well, the answer to the question was, did you speak to Jennifer that morning? The answer was no. The court understands the second question to be, did you attempt to contact her that morning? You may ask the question again. John.
Did you attempt to contact her that morning?
No,
Did you have her phone number at the time?
of course.
Do you recall what that number is today?
Objection, Your Honor.
Sustained.
I have no further questions.
I have nothing further. Thank you.
Ms. Barber, you may step down.
Thank you.
So that's just to prove that we haven't seen her, and that's kind of a basic thing. You got to show like, well, where is she? Wow, where is she? Mm-hmm.
State rest, Your Honor.
Ooh, state is
Ladies and gentlemen,
rested.
What that means is the state at this time.
Means they're
rests the case.
tired.
The state, if the defense puts on witnesses, the state has an opportunity, if it so chooses, to present rebuttal witnesses. But as of right now, the state rests its case. The court has to take up at this point legal arguments. And if the defense has witnesses ready to be called after those legal arguments, we will resume session. So please do not discuss the case.
So
And we probably are going to be in a much longer recess than normal. Are there defense witnesses ready for today, Attorney General?
Yes, Your Honor.
Are they ready this morning?
We were informed that they would arrive by 11. We didn't know how long the state's case would take.
Thank you. So we'll stand in our recess, ladies and gentlemen, until 11 o'clock.
now, see, that's to be fair, guys. That's not an obnoxious thing to say. Like, well, we thought we'd be ready by 11. Judge is like, yeah, you know what? I don't think they anticipated. Like, I thought they'd introduce a death certificate or something too, but they didn't do that. Which I'm surprised they didn't do that. That she's been legally declared dead. You think they would do that just to ascertain proof that she's been legally done, but we're gonna get to probably a directed verdict. Here we go. They're gonna ask for a directed verdict, so let's do this.
The defense has an opportunity to argue its motion for judgment of acquittal. That motion was filed yesterday, February 20th.
Yes, and I'll note that originally we thought the state would complete yesterday, so even though it's dated yesterday, it's to take effect at this point now that the state is rested.
Thank you.
I move for the court to grant the judgment of acquittal on each of the present charges, each count separately, and I will just go through each of them. The state has presented, and again, the standard for motion for judgment of acquittal, is there any evidence that the jury could find beyond a reasonable doubt that the state has met its burden on each and every element of the offense charge? Let me just begin where I will concede that there is sufficient evidence of certain elements that would have to be resolved by the jury. So, for example, I believe the state has been able to show that a jury could find that Jennifer Dulos is deceased. We would also concede for purposes of this motion, that the death of Miss Barbara Dulos was either induced by or caused by Fotis Dulos, either directly or indirectly. What I submit that the state has failed to establish is whether that death was caused by the specific, under the common law, we call malice aforethought, which means intentional killing of another individual under the statute providing for the elements of murder. That, however, even if the state could do that, even if the state can argue that there's sufficient evidence to show that Fotis Dulos planned the outcome that occurred, we have to also remember, Your Honor, that much of the state's evidence is based on this presumptive testing, which I note under State versus Moody, in and of itself fails to provide any evidentiary value whatsoever. So even though the jury and the court hasn't yet fully instructed the jury, the court made some comment to the jury about what it's allowed for, but Luminol and Castle-Meyer are not evidence of blood. So the fact that there's been a lot of testimony about that, it's in the interrogation videos, it was the subject of many witnesses' testimony, it does not provide any basis for the court or for any fact finder to determine that that was in fact blood. And for reasons that we still don't know, the only three items that were tested, and we concede one of them being the shirt and the other being the rock. I forget what the third one is right now, but it was one other place where they did test, and it was determined to actually be not just a blood-like substance or something that tested under a presumptive test, but was in fact blood. The problem with the state's theory of this case, and as it was presented, is that the state spent a month or more trying to prove that Fotis Dulos killed his wife. None of that, however, none of that evidence pointed to Ms. Troconis as being a party to that plan, that design, or the acts involving the death itself, or the cover-up afterwards. I would readily concede that the court proved that Fotis Dulos was involved in the covering up of a crime. Whether that crime was murder, as the state alleges or some other crime, again, the way it's been charged, that it could only be murder. It cannot be manslaughter. It cannot be a reckless death during a fight or struggle. It has to be murder because that's the way the state charged this offense under count 1. In fact, the way they charged it is they say that Fotis Dulos, quote, did assault Jennifer Dulos in her home on the 24th day of May, 2019, with the intent to restrain and kill her in violation of sections 53A, 48A, and 53A-54A, subsection A. I will note there has been no evidence from any source of any restraint, but let's just assume that there's still enough to at least allege that there was an intent to kill, even if I submit the evidence doesn't support that. But now we get to the question in count 1 of conspiracy. Under our law, under Connecticut General Statute 48A, the state must demonstrate essentially 4 things. One being the underlying purpose being to restrain and kill Jennifer Dulos. The first question is they have to prove that Michelle Troconis intended to commit that crime, the specific crime of murder. 2, that there was an agreement between Michelle Troconis and Fotis Dulos to commit that crime of murder. 3, that the specific intent was to restrain and or kill, not or, Jennifer Dulos. And 4, if there was an actual agreement to do those things together. Now, the state has alleged that the defendant agreed with other persons, quote unquote, to engage in these crimes. The state is not required to actually place in their information who those other people were. We've heard the names of possible other individuals. There was Kent Mowini, there was Andreas Koutsiartis, there was even Pavel Gumieni, as people that may have committed acts that might be considered certainly suspicious, but the state made no effort to demonstrate that Michelle Troconis agreed with any of them to commit an offense. I now want to just talk about the count. Basically, I'm going to not repeat what I'm saying about the crime of conspiracy, other than conspiracy is a specific intent crime. Not only do you have to prove the underlying elements that the defendant was involved in, but that she had a specific intent to agree to commit those offenses in advance. If one looks at and I'll start with count 2. Count 2 specifically alleges that Michelle Troconis entered into a conspiracy on 24th of May, 2019, in the area of Albany Avenue in Hartford, to commit the crime of tampering with physical evidence with the intent that conduct constituting that crime be performed, did agree with Fotis Dulos to engage in and cause the performance of that conduct. And one of them, I would submit the only other one is Fotis Dulos, did commit an overt act in furtherance of the conspiracy. It goes on to say that Michelle Troconis traveled with Fotis Dulos to the Hartford area for the purpose of disposal of physical evidence relating to the murder of Jennifer Dulos in Hartford on May 24th, 2019. That's the allegation that's been submitted. I submit there is no knowledge, no evidence whatsoever that Michelle Troconis either agreed to do that or had any idea what was going on, what Mr. Dulos was doing. We've spent, I don't know how many hours of interrogation video. She never, so we start with the fact she said absolutely nothing that would constitute admission to any knowledge of that. To the contrary, she repeatedly, over the course of months, denied any knowledge as to what Dulos was up to. So what is the evidence with regard to that? We do know, let's work backwards. The police did not come to the home of Dulos and Mr. Troconis until approximately 8:30 the night of May 24, 2019. The testimony is they came to the house and told Mr. Dulos, and my client heard part of this, that Jennifer Dulos was missing. This, of course, is after they were in Hartford on Albany Avenue. So we have black garbage bags, opaque garbage bags. We see Mr. Dulos placing them in various receptacles. Only one of them, incidentally, contained any items of evidentiary value to this case. The ones where the 2 garbage bags, the shirt, the bra, a number of other items that were found with blood on them. They weren't in garbage bags. It was spread among whatever trash was in that barrel. But be that as it may, the evidence is uncontested that it was Fotis Dulos who got out, took the garbage, and threw them in those barrels. This is prior to any time that Michelle Troconis would even know that there was a crime that may have occurred and that there was an investigation that was beginning. So in order to be guilty of tampering with physical evidence, it specifically requires under the statute, that under 53A-155, that the defendant would have to believe that a criminal investigation conducted by law enforcement or is pending or about to be instituted. And therefore, it claims that she either destroyed, concealed, or removed anything for the purpose of impairing its ability to be used in the criminal investigation. Again, the only evidence is that she only even learned that there was an investigation afterwards at 8:30 at night, after they had been to Albany Avenue, after they'd been to Starbucks, and then they went home. So I submit that there is zero evidence in the record to allow any reasonable trier of fact, to conclude that she engaged in that conduct or agreed in advance to that conduct, either substantively or in a conspiracy to commit that crime, in the absence of any evidence that she knew there was a criminal investigation at all, or that even one was being instituted. If I may move on. I will also note, Your Honor, that there's a lot of cases that specifically say that mere presence or even acquiescence in the conduct of someone else is not evidence of a crime. And a jury has to be instructed that that cannot be used as the basis. There has to actually be affirmative evidence. Merely being present under our law is not a basis to convict anyone of any crime, even if they're sitting there while someone else is engaged in obvious activity in their presence. Count 3 is the substantive offense of tampering with physical evidence, again, under 53A1, 55A1. It is charged as accessory under 53A-8. I note that under our law, the crime of accessory and the principal crime are the same. They are two manners of committing the same crime. But the way it's been charged here, it indicates that simply that she committed the substantive crime. I guess there's zero evidence that she did that. She didn't touch anything that's connected to a crime in the city of Hartford on May 24th, 2019. I will note, Your Honor, I'm anticipating what the state's going to say. Well, there were 3 cells of partial DNA of Mr. Troconis found on the exterior of the opening of the bag. So the place where you would hold it, you grab a bag, might pull it out of a box, but it was partial. And the state did not test either Mr. Troconis' mother or her daughter, who also lived in the home, even if they can assume that these garbage bags came from that box of trash bags that was seized from the home itself. There's an interesting recent Connecticut Supreme Court case on this that Your Honor should be at least aware of, that I want to cite. State versus Dawson at 340 Connecticut, 136, 2021. That is a case where there was a firearm discovered where they were in the immediate vicinity of 3 or 4 individuals. And the Supreme Court in that case ruled in 2021 that DNA evidence standing alone does not establish that the defendant had dominion or control over that weapon. So they reversed the conviction, saying the presence of DNA, and they went into this issue of partial DNA, the number of picograms, the idea of transfer DNA. They say that is not enough to convict anybody. And I submit that that is precisely where we're going with this particular case here, and the suggestion that 3 cells that are a partial match to Mr. Troconis cannot be the basis for such a finding with regard to that charge. Now let's move then to counts 4, 5, and 6, which all relate to the Russell Speeder car wash in Avon, which is where the state alleges. So we're talking about we're talking about what happened in Mountain Spring Road. That is not the charge. The fact that Mr. Dulos handed Mr. Troconis a paper towel that did not smell like anything that she put in a garbage bag is not what they're charging here. It's according to the way this case was charged. It says that she both tampered with and hindered the prosecution by, did agree with Fotis Dulos, by transporting the 2001 Toyota Tacoma used in the commission of the murder of Jennifer Dulos to Russell Speeder's car wash for the purpose of having evidence relating to that murder concealed and destroyed. The count 5, tampering, specifically indicates that believing that the criminal investigation was pending or about to be instituted, altered, destroyed, concealed, or removed a thing with the purpose of impairing its availability in the criminal investigation. And finally, under hindering, it rendered criminal assistance, as that is defined, to another person that she believed committed a murder. I mean, it specifically committed a Class A felony, to wit murder, did provide Fotis Dulos with transportation and other means of avoiding discovery and apprehension. Well, even that is baseless here, Your Honor, because she did not provide transportation to Mr. Dulos to bring the vehicle there. The only testimony is that she followed outside in a separate vehicle, I guess on May 29th, which is what the allegations are here, and then picked him up at the car wash. The only reasonable interpretation is she was somewhere outside, not even visible. He had to call her on the phone to come get him. Of course, this is after the vehicle has been brought in, and the testimony is they then together drove down to Attorney Bowman's office in Westport. And then when he came back, we had the video. Mr. Dulos obtained some cash and went inside and paid for the detailing after it was done. There is no evidence that Mr. Troconis had anything to do with that. There's no evidence that she had any involvement in that bank account, that she even would have known what he was taking out and for what purpose. He went in alone to have the car detailed and washed. He alone went in to have it pay for it after the fact. And I just want to also clarify, because it took a little bit. So we got Detective Clavy yesterday to admit it. I'm sorry, Detective Kimball to admit it. But even Mr. Dulos did not falsely give information about the Toyota Tacoma to the aide. That in fact, the employee had mistakenly written the phone number on the line of a vehicle that came at 8:44 in the morning, and then rewrote it on the line below where it didn't indicate the name of the person who was bringing in that vehicle. So I don't need to repeat. For each of the crimes, you have the same elements. For hindering, all requires specific intent. They have to specifically show that the purpose was to commit specifically a crime, a Class A or B felony, that you had to be aware of that. In this case, it had to be by the way the case was charged, murder, not any other crime, not any other crime. There's just one other. And when I refer to the log sheet, I'm referring to State's Exhibit 138, the Russell Speeder log that was introduced, and which I showed as well to Mr. Kimball yesterday. So just have a moment. I know that, and I'm just going to say this for the record. I know that Judge Lowy denied this, but I want to incorporate my arguments about vicinage and venue for my judgment of acquittal in the case, that vicinage is a requirement of the location of the crime, and that all of these crimes, all of them, including the conspiracy, all occurred in the Hartford Judicial District. I stated for the record, I'm not asking the court. I would ask the court. I don't want the record to suggest that I waived the issue, so I raise it now so that the court is aware that I'm making that also part of my judgment of acquittal argument at this time. You just look at my notes for a moment, Your Honor. When I made the comment about mere presence as an inactive companion, passive acquiescence, or the doing of innocent acts which may in fact aid the one who commits the crime, must be distinguished from the criminal intent and community of unlawful purpose shared by one who knowingly and willfully assists the perpetrator of the offense in the acts which prepare for, facilitate, or consummate it. That's from State versus Caanan, which goes back to 96 Connecticut 420. It's also cited in State versus Pundy, P-U-N-D-Y, at 147 Connecticut 7, where the court went on to say that those who simply are companions in passive acquiescence may be said to be innocent of any wrongdoing. Just want to check my notes one more time. I'm just going to mention, in case the state, instead of standing up a second time, I'm going to just mention Pinkerton liability in case that's one of the state's arguments. That doesn't apply here. And I will note that under Pinkerton, such cases as State versus Bennett at 307 Connecticut 758, which cites to the Pinkerton decision at 328 US 640, require a community of criminal intent and community of unlawful purpose with the perpetrator of the crime, and must be knowingly and willfully done to assist the perpetrator in the acts which prepare for, facilitate, or consummate it. Under those cases, Your Honor, and there's numerous cases that now deal with the Pinkerton liability, that applies when if somebody is going to rob a bank and they conspire in advance to rob the bank, and there's evidence of that conspiracy, but one of the co-conspirators pulls out a gun and either shoots someone or at least threatens the gun. The co-conspirator can say, well, I didn't know he had a weapon. But under Pinkerton liability, if it's within the furtherance and it can be believed to be a likely alternative or outcome that could happen if you're going to rob a bank, there's an inference that it may be probable somebody may be armed. You can be held liable to the more what's the best way to put this? To the enhanced penalties or the aggravating factor that would be contemplated within the crime accused. But you have to go back to knowing what was happening in the first place. If you go to the bank, for example, to make a deposit, and the person you're with robs the bank, pulls out a gun and robs the bank, if there's no evidence of an agreement, you're there just to make a deposit. That could not then subject the person to Pinkerton liability merely because he or she was present. In other words, it doesn't shift that liability and do away with the requirement of concert and concerted effort and agreement to commit the crime.
Well, the touchstone of Pinkerton is foreseeability, correct?
I'm sorry, Your Honor.
The touchstone of Pinkerton is foreseeability.
Foreseeability, that's right. And of course, and I also, when I read Pinkerton, it's not only just foreseeability that one of the people will do something else, but you are already committing a crime. It is not foreseeable that if you go into the bank, a friend of yours may commit a robbery. It's that you agreed in advance. It's just that it's foreseeable that maybe that other person that you already agreed to commit the crime with did something more egregious than simply ask for money and hand up a note. So that's the claim that I'm making with regard to that. There was just one other point, Your Honor, that I wanted to make before I sit down. I'm just going to ask the court, there are a couple other cases that have come out that I wanted the court to look at on the issue of with tampering, for example. They are State versus Knox, KNOX, 201 Connecticut, appellate 457 in 2021. And they talk about State versus Jordan, which is in 2014, 314 Connecticut, 354. They talk about that that's where it specifically says, even though the statute is not as clear, that you had to have acted with the intent to prevent the use of the evidence at an official proceeding or criminal investigation. And it construes in that respect the difference between that case and State versus Forshaw, F-O-R-E-S-H-A-W, at 214 Connecticut 540, where there was some debate between whether it was required or not. And I submit the Jordan case and then the Knox case make that clear. I also want to make one other last argument here. There is going to be some evidence suggested by the state that if Mr. Troconis made false statements or intentionally made false statements, which of course we dispute, but let's assume that based on the testimony, the jury could find that she made false statements during the interrogations. That evidence, Your Honor, was admitted for purposes of arguably consciousness of guilt. And we will be submitting a jury instruction that they have to first find that it was intentionally false as opposed to based on either mistake, misremembering, being coerced, all those things that we've talked about. But the case law on consciousness of guilt makes clear, and the judge must instruct the jury, that consciousness of guilt is not evidence of the crime itself. So the state would have to prove separately that the defendant, that there was sufficient element of the crime, each element of the crime, and then apply whether, I'll use flight as the example. If a person runs away when the police come and somewhere in a group of people they find drugs, that fact of somebody running away is not evidence that the individual possessed those drugs or possessed it with the intent to sell. It's admissible to show a guilty conscience. And that would only be admissible if there was separately sufficient evidence of the underlying crime beyond reasonable doubt or crimes. Just one moment, Your Honor. Oh, the other case on Pinkerton that I wanted to cite was State versus Patel, which is the appellate court case 194 Caanan 245, 2019. And then I'll also cite to the elements for conspiracy to commit murder, State versus Balbuena, B-A-L-B-U-E-N-A, which is 168 Caanan 194, 2016. And conspiracy to commit murder, State versus Pinnock, P-I-N-N-O-C-K, at 220 Connecticut 765. Based on that, Your Honor, I ask that on each of the counts. I'm sorry, I thought I was done. I realized one other thing. There are 3 separate conspiracy charges charged here. I submit that the state has not shown any 3 separate agreements under any theory, and at the very minimum, the court is required, based on the evidence, to grant the judgment of acquittal as to 2 of them. And the way I understand the law, the court can leave in the most serious one, which would be the conspiracy to commit murder. The court does not agree with my other arguments, but the court must, based on the case law on the issue of a multiplicity of charges, they have not shown there were separate conspiracies at any time. Haven't shown any conspiracies at all. They certainly haven't shown there were separate conspiracies. And based on all of that, Your Honor, I ask specifically, just on this last argument, that the court grant the judgment of acquittal as to count 2, count 4 as a separate argument. Thank you.
Your Honor, good morning. May it please the court. Your Honor, the defense argument seems to be that we have a different interpretation of the evidence and therefore grant us an acquittal. But of course, as
Now,
the court knows, that is
guys-
that the court needs to rely on the court
Oh,
has
hold
to
on.
review the
Damn it.
evidence and
Let's go
allow
too
the evidence
fast.
to state as part of this motion, including drawing all reasonable inferences that it
Okay, so here's where we are. Remember, everything's viewed in the light most favorable to the non-moving party, which is the state. So Schimmelhorn's brought up a lot of good points here, why this doesn't count, why this is invalid, why this isn't fair. But I think a lot of these aren't going to count. This is has the jury started deliberating yet? Not yet, starting next week, but we're catching up yet. This is from Wednesday. And the defense, the state just rested, and they're doing the motion to for directed verdict. So, so that's it. She's innocent. Yeah, I mean that's a totality of the state's case. I am not impressed. She's circumstantially kind of maybe guilty, but remember, kind of maybe isn't good enough. She's not guilty to me. Not guilty in my book. Although I think a lot of it's bad, and I think a jury could ultimately decide, hey, she did this. But we'll find out. Real quick, I wanted to check on this. We'll call Magic for 199 says, matched at Apple pricing. Lol. Well, thank you. Juror 13 for 199 says, this is for all the Baldos fans. Well, thank you. Robert Lawrence gifted 5 memberships. Thank you, Robert. Whoever gets one of those, I know is going to be thrilled to have one. And guys, we are working. I will put it out tonight. We're going to do a live. We are going to do the Brian Laundrie's dad's deposition live for members only tonight over here on YouTube. We are probably going to have to do this day 25 as separate pieces because remember at 4 I'm going over to spend some time with Hella. I'm talking about Tyrone Franklin, and then we'll be back over here. Unhung Hero for $2 says, "Oh, I'm gonna come." Don't come. Don't come. So let's see where the state goes with this. I don't think it's going to be, generally you never win these. So Robert says, at least you can say your attorney did try. Yeah, well, the thing is you lay it all out now. But like I said, typically the judge is going to wait to see what happens. A lot of judges wait to give the jury the chance to do it right. You very rarely get these, you win at this point. That's just the nature of the game. Dr. Mimo says, haven't we seen another case where they say cleaning up after the fact is considered consciousness of guilt? Well, typically it is. Altering a crime scene, destruction of evidence, it can be reasonably inferred to be evidence of, consciousness of guilt. So is flight. Flight can be considered consciousness of guilt. Innocent people don't run, is what they'll say. So, yeah, it's actually very common for them to do stuff like that. So let's see here. So that's not abnormal for that either. Let's get this bad boy going again.
The jury can find in favor of guilt. Including drawing all reasonable inferences that a jury could find in making a finding of guilt. So I want to just begin with the argument that the state has proven that Mr. Dulos is responsible for Jennifer Dulos' death.
4 p.m.
but
Shree,
somehow the
4
state has
p.m.
not presented sufficient evidence for a jury to find that it was actually an intentional killing. That is completely belied by the facts of this case, Your Honor. A reasonable jury can draw the following inferences. Number one, Mr. Dulos was motivated to harm Jennifer Dulos based on the fact that they were involved in a highly contentious divorce. Mr. Dulos drove his employee's Toyota Tacoma to New Canaan to commit this crime. He attacked Jennifer Dulos in the garage and killed her with at least 2 blows. It's been about a month, but you'll recall, Judge, we had the blood pattern expert who came in and indicated that there were at least 2 blows which were delivered in this case based on the direction of the blood pattern. By the way, the fact that he was in New Canaan in the first instance, Your Honor, is evidence of his intent because he had no reason to be down there. The children did not have visitation on that day, and the fact that he went down there in the first instance is evidence of his intent, including the fact that he took his employee's vehicle. State versus Moody does not stand for the proposition that the defense keeps citing. State versus Moody, I know the court knows this, but it's the totality of the evidence in this case that is the dispositive factor, including the fact that all of those presumptive blood tests subsequently tested positive for Jennifer Dulos' blood. So that's the compelling factor in this particular instance. A reasonable jury can also find that Jennifer Dulos was transported from her home by Mr. Dulos and her body was disposed of in some manner, which again goes to the intent in committing the crime in the first instance. A reasonable jury can find that her clothing was removed by Mr. Dulos and disposed of in the trash on Albany Avenue, thus demonstrating his connection to the blood, the clothing, and his active murder. And I would just cite the court to State versus Richards, 196, Connecticut 387. The state does not need to prove the cause of death in a murder case merely that it was caused by criminal means. So in other words, the fact that the body has not been recovered does not mean that the jury can't find that there was homicidal violence in this case, particularly when you combine the blood pattern evidence with the cut clothing, with the fact of animus towards Jennifer Dulos and Mr. Dulos' DNA in a mixture of blood with Jennifer Dulos' DNA. on that faucet. Now, counsel say, well, there was no confirmatory test done. That's not the test. It's not whether or not a confirmatory test was done. The test is whether or not a reasonable jury could find. So here you have Mr. Dulos' DNA mixed on the faucet with Jennifer Dulos' DNA. It's a blood-like stain that tests positive for blood, which is strong evidence of his guilt. Now, that is, of course, evidence of Mr. Dulos' intent, but let's talk about the evidence of the defendant's intent. I would direct the court to State versus Soini, 180 Connecticut 205. That was a conspiracy to commit murder case, and the court in Soini specifically talked about one of the factors, of course, for a jury to consider is whether or not somebody who is alleged to have entered into a conspiracy would have been motivated to enter into that conspiracy. So let's talk about all the evidence of the defendant's motive that the state has established during the course of this case. And I would just note also that there is no requirement in a conspiracy case that the state present a witness who comes in and says, I agreed or I heard an agreement. It can absolutely be proven by circumstantial evidence based on the fact that conspiracies by their very nature are done in secret. And there's a whole line of cases, Your Honor, that stand for that proposition. So the evidence of the defendant's motive here, obviously, number one, her boyfriend is in a contentious divorce with Jennifer Dulos at the time. In part, incidentally, due to the fact that the defendant and Mr. Dulos had an affair and Jennifer Dulos left the house shortly thereafter with the children. They were in a custody battle that necessitated the defendant having to leave the home whenever Mr. Dulos had visitation. She was not to be allowed around the children. During her interview, the defendant actually said that this had been 2 years of torture. She talked about applying for a restraining order against Ms. Dulos. She discussed the fact that her relationship with Mr. Dulos was suffering as a result. And in fact, the defendant told Mike Meehan that she had not moved to Connecticut for this. The defendant also told investigators that she was prepared to leave Mr. Dulos as early as December 2018, and the jury could infer that she was going to leave because of the fact that this divorce proceeding was driving a wedge into her relationship with Mr. Dulos. The defendant was obviously, a jury can infer, extremely upset and motivated to harm Jennifer Dulos, as evidenced by the fact that she stated, when referring to Jennifer Dulos, that that bitch should be buried next to the dog, thus demonstrating severe animus towards Jennifer Dulos and explicitly referencing her death a month or so leading up to Jennifer Dulos' disappearance. And even after Jennifer's disappearance, the defendant's animus towards Jennifer Dulos continued, as evidenced by the fact that she told Pavel Gomini that she was going to, quote, kill Jennifer when she turned up. Now, the defense will say, well, that proves she didn't know. The jury doesn't have to accept that. The jury can accept that as merely a self-serving statement in an effort to cover up her involvement in the crime, but while still expressing severe animus towards Jennifer Dulos. The jury can also infer, Your Honor, reasonably that the defendant had advanced knowledge of the murder and actively tried to help Mr. Dulos with his false alibi. After all, the defendant was home at the time, or the approximate time of the murder, and purposely, the jury can infer, answered his phone to help establish his alibi, as evidenced by the fact that Mr. Dulos wrote in his alibi script that he initially answered the phone. The phone call, of course, was from Mr. Dulos' friend, who subsequently refused to cooperate in the investigation, and that call, according to the data, had been arranged the day before. The defendant, of course, did not mention this call in her first two interviews, and in fact, indicated in the second interview that she had not seen Mr. Dulos' phone at all. The defendant actively lied about Mr. Dulos' whereabouts on the morning of the crime, even after being told that Mr. Dulos was responsible for Jennifer Dulos' death. And the evidence is, if Mr. Dulos was in New Caanan killing Jennifer Dulos, which the defense has essentially conceded, although they don't concede the intent, that the defendant was home alone with Mr. Dulos' phone and manipulating it. That's the evidence. She's unlocking the phone, she's playing with the phone at times when Mr. Dulos is in New Caanan. And that, again, is something the jury can draw a reasonable inference that this whole thing with the phone call was a planned event. The defendant was in possession of his phone, waiting for the call that had been prearranged the night before. The jury can also infer, Your Honor, consciousness of guilt based on the fact that the defendant actively assisted Mr. Dulos in attempting to conceal evidence of the crime, thus demonstrating a consciousness of guilt with respect to the conspiracy to commit murder. And that, of course, serves as the basis for counts 2 through 6. The defendant incidentally says that the court at this point needs to make a finding that it was one conspiracy. They cited no case for that proposition, Your Honor. It's just simply false. A reasonable jury could reject some or all of these counts, and it's up to the jury to decide whether or not the state has proven each element of each crime beyond reasonable doubt. They cite no case for that proposition whatsoever. But nonetheless, those counts. The defendant, I guess, was claiming that because the state didn't indicate evidence of others being involved in the crime. Number one, that's not true, because we have the testimony regarding Mr. Dulos' friend making the phone call, not cooperating, but also not required for conspiracy to commit murder. The only thing we have to prove, Your Honor, is that she agreed with one or more persons. That's the state of the law. So it's false to say that we somehow had to prove that she conspired with other people besides Mr. Dulos. With respect to the tampering counts, Judge, we have charged her under an accessorial liability with respect to that. The test is essentially that the defendant believed an official proceeding or criminal investigation was pending or about to be instituted, helped Mr. Dulos discard the evidence at issue, and acted with the intent to prevent the use of evidence at an official proceeding or criminal investigation. I'll direct the court to State versus Forsaw, which is 214 Con 540. In that case, evidence that the defendant had discarded a murder weapon before any contact with police officers or the judicial system was sufficient to convict the defendant of tampering with evidence. So there's no requirement, Your Honor, that actually an official proceeding ever begin or the timing of it, merely that the defendant believed one was about to be initiated. So what can the jury find with respect to counts 2 and 3? The reasonable jury can find the following: that the defendant agreed to assist Mr. Dulos in the destruction of physical evidence and assisted him based on the following. She was present at 80 Mountain Spring Road shortly after the Tacoma arrived and drove back and forth several
Your
times.
Honor, I apologize. The state may interpret a moment. We're having a technical issue.
Certainly. Can I proceed?
Yes.
Thank you very much.
A reasonable jury can find that she was present at 80 Mountain Spring Road shortly after the Tacoma arrived back and after this crime was committed, and that she drove back and forth several times. A reasonable jury can find that she believed a police investigation was about to begin and that she was actively helping Mr. Dulos, as evidenced by the fact that she brought cleaning supplies. A reasonable jury can find that she accompanied Mr. Dulos to Hartford and was present as he disposed of those items, and that she actually assisted him in the disposal of the license plates by opening her door at the exact moment that he opened his door and left it open until he dumped those license plates in the sewer. If you look at the video very carefully, Judge, what you're going to see is a vehicle there that she's attempting to block, and a reasonable jury can make that finding. She's trying to block the view of that particular vehicle. A reasonable jury can find she was aware of what was in the construction bags, as evidenced by her many lies about the entire day, including the fact that she was present at 80 Mountain Spring Road and was going back and forth repeatedly and apparently lighting fires, which is again consistent with the destruction of evidence. She actively assisted in the cleanup process prior to going to Hartford, including bringing cleaning supplies, which incidentally were consistent with those which were found in Hartford, including a green and yellow sponge, a broom or a mop handle, and black garbage bags, all found in Hartford that the defendant admitted to bringing to 80 Mountain Spring Road. The defendant's DNA is located on the opening of a bag that tested positive for blood, had Jennifer Dulos' DNA, and had duct tape, and was found amongst other bags matched to Jennifer Dulos' untimely death, specifically a bag that contained a bloody shirt and bra confirmed to be human blood that was forensically linked to the DNA of Jennifer Dulos. With respect to counts 5 and 6, Judge, a reasonable jury can find that the Tacoma was used in the commission of this crime, and the defendant assisted Mr. Dulos in his effort to conceal evidence found within and upon the Tacoma. As the court knows, the Tacoma was viewed on video surveillance leaving 80 Mountain Spring Road in the early morning hours. It was tracked on surveillance footage heading down to the New Caanan area. It was parked near Waveney Park in the general area where Jennifer's Suburban was found. Approximately 40 minutes or so after Jennifer's Suburban was viewed leaving her residence, the Tacoma was seen traveling north on the Merritt Parkway, where it essentially tracked right back to 80 Mountain Spring Road. A reasonable jury can conclude that evidence relating to the crime of Jennifer Dulos was inside of that vehicle based on, number one, her blood being present, and yes, they can make that finding on one of the seats. The defendant's acknowledgement that Dulos was cleaning the vehicle, and Dulos' paranoia and insistence that Mr. Gimini get rid of the seats from the Tacoma. Moreover, a reasonable jury can conclude that the defendant was at 80 Mountain Spring Road during the cleanup of the Tacoma, and in fact admitted to assisting Mr. Dulos throw away a paper towel that apparently was being used to clean the Tacoma. The fact that she says it's coffee is not dispositive. The jury can merely view this as a self-serving statement, especially in light of all the other evidence in her lies. The defendant took the keys to the Tacoma, and a reasonable jury can conclude that she took the keys to the Tacoma because she understood that Mr. Dulos had used it in the commission of the crime, and they wanted to keep the Tacoma in Farmington so they could continue their efforts to clean up. The defendant drove in tandem with Mr. Dulos to the car wash, knowing that he was going to wash the car in an effort to conceal evidence of the crime. Again, a reasonable jury can make that finding, especially given that she initially tried to sort of fudge those facts to the police and lie about it and say that he called her to come pick him up. And then when she's pressed, she says, oh, well, maybe we went together. The Tacoma was extremely clean when it was found by investigators. So clean, in fact, that despite the fact that it was an 18-year-old work vehicle, there were numerous places where there was no DNA profiles at all, thus showing evidence of the destruction of evidence in the cleanup. DNA expert Kristen Maydell testified that DNA can be destroyed by wiping it or using water or shampoo. Thus, a reasonable jury can conclude that there was evidence destroyed in connection with this case. The defendant also showed consciousness of guilt with respect to this by not telling investigators that the Tacoma was at 80 Mountain Spring Road, thus demonstrating her understanding that this was used in the commission of the crime during her first 2 interviews. The defendant also failed to tell the police that this vehicle had been washed during the first 2 interviews, again demonstrating consciousness of guilt. With respect to the hindering count, Your Honor, obviously, the defendant, by following Mr. Dulos out, meeting him at the car wash, and a reasonable jury can infer that she understood that the crime of murder had been committed. Incidentally, this is 5 days later, but certainly, Judge, a reasonable jury can infer based on all the evidence that she understood that that vehicle was evidence of a crime, and she picks him up and provides transportation, essentially through the use of her vehicle, back to the car wash so that these things can be done. And she also, coincidentally, her phone number is the number that is used on the call log, which again, a reasonable jury can view as an effort to distance Mr. Dulos from the car wash. Perhaps they thought that she wasn't under investigation, even he was. And again, a reasonable jury can make all of these findings. So, Your Honor, again, this isn't a motion about we have a different interpretation of the evidence. That's what closing argument is for. The question for this court is, has the state presented sufficient evidence to proceed? And of course we have, Your Honor, based on our argument. Does the court have any questions?
Yes. The court is reviewing the information that the court read to the jury. That information was filed on or about October 5th, 2023. The court is reviewing count 5.
Sorry, guys, I forgot to turn the sound up.
I don't have a copy in front of me. Sure. Thank you.
And the information reads, the court is just going to read the pertinent part. On the 29th day of May 2019, in the town of Avon, in the area of 265 West Main Street, that being Russell Peters, the defendant, Michelle Troconis, believing that a criminal investigation conducted by a law enforcement agency was pending and about to be instituted, and an official proceeding was pending and about to be instituted, did alter, destroy, conceal, and remove a thing with the purpose of impairing its availability. What evidence did the state introduce on that count?
Yes, sir. The evidence is the car wash itself. And if I may just be heard on this, because I did hear Attorney Schoenhorn's argument, but we charged her as an accessory in this particular count, Your Honor. And I know that I didn't think that this was going to be an issue, but I'm happy to provide the court with the case law. But essentially, by putting the accessory statute, we put the defendant on notice that that is a theory that we are pursuing. And so the court needs to view that count in light of that allegation that she was an accessory. And so the fact that the Tacoma itself was brought to the car wash, if a reasonable jury can infer that the Tacoma itself was used in a crime, then the jury can infer that she aided Mr. Dulos in the tampering of that evidence by providing him with transportation, by allowing her phone number to be used and that the destruction of evidence happened. So there is no requirement, Your Honor, based on the way that we've charged this, that we prove that she actually altered the evidence herself, because we charged her under an accessorial liability theory.
Thank you, sir.
Very briefly, I just want to respond to a couple of things. I'm actually a little surprised to hear Mr. McGinnis say that the luminol was tested and confirmed to be blood on all these items. That's simply untrue. There were 3 items total that were tested. None of the others were tested. This all goes back to the suggestion they can infer it was blood from that is not only improper, but I submit that they argue that point to the jury. That's considered prosecutorial misconduct based on that. So I submit that that's just a erroneous statement. With regard to the bold assertion that Mr. Dulos was in New Canaan that day, and so therefore he wasn't home, I submit there's no proof of that. We concede he had something to do with a plan, but they cannot prove that it was Mr. Dulos who was there on May 24th, in light of the fact he was there on May 22nd. And therefore they cannot, as I cited, I don't even hear the state referring to that recent Connecticut Supreme Court case on DNA that I just cited a few minutes ago. So, and about transfer DNA. But be that as it may, there is not evidence that all of these other items were tested and found to be positive for Jennifer Dulos' blood. If there's evidence of homicidal, let me rephrase that. Evidence of a homicide, that does not prove intent. That doesn't prove murder. It proves an untimely death. And a motive, even if a motive exists, is not equal to a conspiracy. There may be a lot of people that you might wish ill will to, but in the absence of either knowledge or actual overt action, it doesn't translate that into finding, well, if you don't like somebody, that's the motive to kill them. The argument that she, quote, actively concealed, unquote, evidence of the crime is also completely speculative and made up. The fact that there was a fire in a fireplace during the afternoon, the suggestion they can say, well, she must be burning evidence of a crime. She must know that there is a crime being committed, that therefore the fact that there's a fire in her fire.
The biggest thing is they never examined those ashes. So what was in those? Did they ever try to go back and get a warrant? Examine those. Was it like the plastic? Was there any plastic in those ashes? The polymers? They don't do any of that. And I think that's a big problem for the state. They dropped the ball there. So introducing this, oh, well, there was smoke. Well, what was in that? Was any of Jennifer's remains in there? That apparently they never checked any of this shit. So it's very surprising. Like, they did a lot of investigation here, but the state was really sloppy at the end of the day in this. I mean, I don't know about you guys, but that's how I'm looking at this. I mean, because let's say there was a fire going, but then they found a completely vacuumed out fireplace. Well, that's sussy. But they didn't do it.
Fireplace is proof of that. I submit would be pure speculation. In fact, half of what I just heard is speculation upon speculation upon speculation. I would note that Mr. Gumieni, for example, did not identify the red truck that was on the side of Latham Road as being his. The only time he identified a vehicle as looking like his was somewhere on the Merritt Parkway. There's the one angle from the rest stop on the, and I can't remember as I'm standing here whether that was Fairfield or New Canaan, but I believe it was Fairfield, where he said yes, because it has that bar in the front. We recognize that. None of the others are identified by Mr. Gumieni as being his vehicle. So I submit there is no evidence that that's the truck on the road. What's more important and kind of interesting, Your Honor, there's no evidence of when the Chevy Suburban ended up on Latham Road until 8:30 p.m. when it was discovered by the police. There is zero evidence it was there during the day. There's no vehicle. There's no one who passed by that saw it. There's no cameras from any buses that show it there at any other time. And we do have evidence that that a phone that's been paired to that vehicle since 2018, and which evidence shows she was going to see Dr. Geronimus. So that is her phone. The state objected to my asking Ms. Farber about that, but it's obviously clear in light of the testimony that that phone was Jennifer Dulos' phone paired to that vehicle at 2:56 p.m. on the afternoon of May 24th, 2019. And the state concedes that Mr. Dulos was in Farmington at least 1 o'clock or so on that afternoon of the 24th. The idea that, I'm not sure I misunderstood Mr. McGinnis, so I apologize in advance, that he said that that they don't have to show who these unnamed speculative co-conspirators were. I don't know if he said that they didn't have to show which one of them she conspired with, or he said the opposite, that they don't have to name other people as long as they prove beyond a reasonable doubt that she conspired with Fotis Dulos. I also submit, Your Honor, because I prepared for that the state misled and misstates the holding in State versus Forshaw, which I also cited. In Forshaw, the defendant actually shot someone in the presence of numerous witnesses, then fled, then got rid of the weapon. In that case, the Connecticut Supreme Court held that it was obvious that there would be a criminal proceeding that was going to be commenced because she knew there were witnesses, and the fact that she fled from it was, it was obvious to anybody that there would be a criminal proceeding pending. We're talking about here what's basically hindsight bias, hindsight creation of what someone should have figured out after the fact based on what was happening at the time. At the time, there was no evidence whatsoever that Michelle Troconis knew what Fotis Dulos or anyone he conspired with or aided did to Jennifer Dulos on that day. And there's also no evidence. She did not provide, this is also clear, she did not provide transportation to Mr. Dulos to go to the car wash. She was going to an appointment with her lawyer, and she picked him up at the car wash and brought him down to Westport with her, and he drove. That's the only evidence that's in this case on that point. Finally, There was no evidence of blood. I want to be clear in that Tacoma. None. There's no evidence she cleaned the Tacoma. She didn't even see Dulos cleaning the Tacoma. All she knows is he handed her a paper towel, said that he had spilled coffee, handed it to her, and she put it in a garbage bag. Whatever he was doing inside that Tacoma, there was zero evidence that she saw him. In fact, Pavel knew what he was doing. Pavel was told by Dulos that there might have been a hair of his wife in there, so he wanted him to take out those seats. So if anyone had knowledge that there may be evidence of a crime in there, it's Pavel Gumieni and not Michelle Troconis. The only difference, I guess, is that Mr. Attorney Urza, representing Mr. Gumieni, had the wherewithal and obtained immunity in exchange for cooperation. That's something that Mr. Troconis did not ask for and did not receive. And that's the only reason I submit she's sitting here today. The only reason she's sitting here today. The state talks about, well, we charged her, the court had a question about the tampering at Avon, at the car wash. He said, well, we charged her as an accessory to alert the defense. But again, you have to act with the exact same state of mind. So the leap of logic that the state is asking this court to jump to, or for that matter, the jury to come to, she must have thought there was some evidence that would lead to a criminal prosecution or criminal proceeding because she picked him up. She left at the same time, but that she picked him up at the car wash, and we don't even know what time that was. We just know the approximate time that the Cole went in to pick her up, to prepare to come get him. But she wasn't even within range that he could just jump into a car and leave. He had to call her on the phone. And the one last thing that I think there's absolutely no evidence, and it's also, again, improper. Mr. McGinnis just said that the defendant allowed her phone to be used at the car wash. That is simply, definitively a false statement. There is no evidence she allowed her phone to be used by Mr. Dulos when a number was written down by the car wash employee. And if the court will recall, just a couple of days earlier, Mr. Dulos' phone, his regular phone, had been seized by the police. And it is just as likely, not just as likely, it's extremely likely that at that moment he didn't know the phone number, is the one that he was now using. So he used one that was in Ms. Troconis' possession when they went down, when they were about to go down to Attorney Bowman's office. So based on that, Your Honor, I tried to respond to the arguments. I'm not going to fight or even contest the fact that there was some kind of untimely death that the jury could find was based on this evidence. I'm just submitting that there is not the evidence that was just submitted by Mr. McGinnis, and the idea that one could put assumption upon assumption on speculation upon speculation and reach that conclusion based on this evidence is not even warm gruel. It is absolutely, there's no logical inferences that could be drawn that could lead to the conclusion that Michelle Troconis knew anything about what's either happened to Ms. Farber or what Fotis Dulos was doing in a criminal conduct in relation to her disappearance. Thank you.
Just quickly, Judge, counsel completely misstates the state's position on these things. What I've said is that a reasonable jury can draw these inferences. Not that these things are definitively in the record at this point. Obviously, a reasonable jury can infer that the defendant allowed her cell phone to be used as evidence in the totality of all the evidence. So he misstates it. I also never said that all these items were tested positive for blood. And I don't think I even used the word luminol in my argument. So I guess we're just making things up now as we argue to the court. But I did just want to follow up on the one issue, Judge, State versus Vasquez, 68 Caanan 194 on the accessory liability issue. I just wanted to give the court one case. I didn't have a chance to research all of them. Just on that count 5 issue.
Thank you. The court will just begin by indicating what the court has to find in a motion for judgment of acquittal. Of course, the court does not have to determine that the state has proven each and every element of each and every offense beyond a reasonable doubt. That's the province of the jury. The court has to determine whether there is sufficient evidence on each count to go to the jury. Now, in so doing, the court cannot, in this court's view, allow to filter into its decision what the court thinks of any witness's credibility. The court is not making credibility determinations in determining how it will rule on a motion for judgment of acquittal. What the court is required to do and is able to do is to determine what, if any, reasonable and logical inferences can be drawn from the evidence that has been adduced. So the court is going to address the motion in just broad strokes. This is in no way a marshaling of evidence concerning intent of the defendant. The jury can reasonably consider that the defendant's remark that Jennifer Dulos should be buried next to the dog is evidence of motivation. The jury need not conclude that. The jury can consider it. That statement was made before May 24. The jury can consider certainly that the blood found on the cut garments in the trash on Albany Avenue is.
Kenny, they did not prove any evidence was burned, but it's Memorial Day, so it's hot as fuck outside. Why is the fireplace running and then it's not running ever again in the middle of May? That's how they're bringing up that circumstantial evidence of suspicious conduct.
Evidence of Fotis Dulos' intent to restrain and kill Jennifer Farber Dulos. The jury can reasonably conclude that because the defendant indicated that Dulos was at home on the early morning hours of May 24, but indicated later on that he was not, that she knew where he was going to go on May 24 and was covering for him. the discarding of evidence on Albany Avenue is an indication that the defendant knew the purpose for which those items were being discarded. The jury can conclude that even though the defendant did not drive Fotis Dulos to Russell Speeders, that there probably was an arrangement whereby he told her, "Pick me up later at Russell Speeders," which means she knew the reason he was going to be there. The jury can conclude these things. Again, the court is not required to assess the strength of the evidence. The court is just required to determine whether or not there is enough evidence to go to the jury. Now, concerning the remarks about multiple conspiracies, the court believes the Second Circuit has concluded that a conspiracy terminates when the central purposes of that conspiracy are attained. So, for example, if the central purposes of the murder of Jennifer Dulos have been attained on May 24th, that's the end of that conspiracy. Then there's another conspiracy. And that conspiracy is to hinder prosecution or tamper with evidence, for example. So the court is not persuaded that the state cannot charge multiple conspiracies. And it is too early to consider at this point any arguments concerning a vacator of any of the convictions, if there are any convictions. So the court finds that there is enough evidence to go to the jury on counts 1 through 6. And the motion for judgment of acquittal is denied. Time is 11:25. We'll resume the session at 11:40. We'll stand in a recess.
All rise. This honorable court now stands in.
I mean, to be fair, guys, yeah, that was. I mean, we knew that was going to happen, so it's not a big deal. So, I mean, and it's not an outlandish ruling. I think, yes, the totality of everything, it makes sense. It's a fair description of everything. So we're just going to go ahead and, I mean, you can get mad at them, but it's a fair judgment, a fair ruling. And now the state's going to start its case, and we got time to roll here, guys. Here we go.
One witness scheduled for today, and probably will not conclude until Monday. Is that correct, Attorney General?
We are endeavoring to complete by Friday, but based on just everyone's schedule and whatnot, we may not conclude till Monday morning, but it's very likely we might be able to conclude by Friday. I'm just indicating the witnesses for each day. If they're not as long as anticipated, then we might be done by Friday. We're trying to have everyone here by Friday, but we would have to cancel if it was running late.
Thank you.
And Your Honor, if I may just be heard briefly. Council has informed the state last night a few names of who may be called today. And prior to them coming out, the state wanted to raise an issue with respect to, I think, 2 of the witnesses outside the jury's presence. So I would ask Your Honor if you wish to do that now or to hold off.
Well, right now, let's just continue with the scheduling.
Yes, Your Honor.
The court is going to assume that the defense will conclude sometime on Monday morning. So what the court will ask both sides to do is file with the court proposed jury instructions by the close of business on Friday. The court will anticipate that the defense will present its last witness on Monday. After the defense's last witness, we will go into the charge conference, which has to be on the record. The court then anticipates after the charge conference, the court will proceed with the contempt hearing. Tuesday morning, closing arguments. Attorney Manning.
Yes, Your Honor. Council informed the state yesterday that they intend to introduce, I'll start with the Farmington police officers, Your Honor, with respect to the evidence concerning the manner of death of Fotis Dulos and essentially the suicide, Your Honor, as well as a suicide note that was found next to him. The state's position, Your Honor, is that this evidence is completely irrelevant to the case. It has nothing to do with Michelle Troconis or the charges that she is faced with, and the state is seeking to be heard on if that evidence is going to be presented, in what way, and some feels that there should be an offer of proof, and I'm requesting an offer of proof with respect to the Farmington police officers that were subpoenaed today. Council also provided the state with the name of a Cheryl Briere. That name appears nowhere in any police report or in connection with this case in any way, shape, or form. So the state is asking for some kind of offer of proof as to what the relevance is of Ms. Briere. I would indicate if it is character evidence, it would not be for truthfulness because the defendant has not testified as of yet. So the only thing the state could assume, and I don't like assuming when it comes to this, is that she would be a character witness or some kind of character trait at issue. I just feel at this point, Your Honor, since Ms. Briere's name is not in any way on any form, report, or in any way connected to the case, the state is requesting either an offer of proof or that she be precluded from testifying.
Do you wish to respond to Attorney?
Yeah, I don't have my witness list in front of me. I don't want to call it a witness list of names. I just want to refer to that first. The name is on the list, Your Honor, so I think that the state's claim is unfounded.
I just want to be clear, I'm not claiming she's not on the list. She was. She's not relevant to anything in this matter. She does not appear on any police report, any statement given, anything that has to do with this case. So the state has no notice as to the content of her testimony. And as such, the state is asking for an offer of proof outside the presence of the jury in order to find out exactly what she will be testifying to.
I will just recall what the court said when we objected to witnesses who were irrelevant. The court said they'll take it up as the witness is on the stand if there's a particular question. We filed, I can't even remember how many, 20 motions in limine. The court did not require the state once to do an offer of proof, not once during their case. So the fact that she's now asking for that for a witness just because she did not, or the state did not go out and investigate people that they've had since October. And I know we weren't required to provide a list, but this name was definitely on the list. There were a number of names we put on that list. The state cannot now claim, well, we didn't know when they failed to investigate the names on the list. As the court is well aware, the defense could have simply called people. We don't have to give the court a preview of what each person is going to testify to. They can object if something is asked that is not relevant. I know the rules of evidence. We certainly wouldn't be called, even if, and I know this is not what we're doing, but even if we were going to put on evidence of, excuse me, of character, even if that was, we would not be required to have that person write out a letter of recommendation to what they were going to testify to. So this is not only unnecessary, but it's also unheard of as far as I'm concerned, Your Honor.
Well, the court will first address the representation by the state that a witness is to be called by the defense to testify about the manner of death of Fotis Dulos. How is that relevant?
Well, first of all, this is not this morning's testimony, Your Honor. So again, I didn't get any opportunity to have the defense. The state has not once had to make an offer of proof towards any of their witnesses. The purpose of presenting the evidence of the fact that he is unavailable as a witness, the state was allowed to state on the record that Mr. Malini was unavailable. I'm entitled in our case to show the circumstances under which he is not available in the case. I do not intend these police officers to testify as to cause of death. It's the fact of death. There's going to be a death certificate that I intended to introduce to show he's not available. So it's relevant to the circumstances, certainly more relevant than I would submit half of the state's case was about the lack of evidence that they were able to present.
Well,
So,
is not a stipulation that Fotis Dulos is deceased?
no, Your Honor, we're not willing to stipulate to that.
Well, the court's question is, for what reason are you calling the Farmington police?
I'm
State representative is to indicate that Fotis Dulos is deceased. So, and then the court understood you to just say that you're not willing to stipulate to that.
I'm just going to note that at no time did this court require the state to
That's not
give
the question. The question is, you just indicated to the court that you wanted to call the police officer to testify that Fotis Dulos is deceased.
No, Your Honor, I didn't say that. I said that
Perhaps the court misunderstood.
yes, it's the individual officer who found Mr. Dulos in his vehicle on the date in question. That is the purpose, and that for the record would be January 28th, 2020. I've heard the state say, well, the jury may have questions about it. There's been some testimony about the circumstances. This is to complete that circle, if you will. And then I would be introducing a death certificate and a decree of death as a certified copy of the decree of probate death, just to close that circle of information. And that is the purpose of that testimony.
The court does not understand what the circle is. The court is under no impression that the jury would have questions about whether or not Fotis Dulos is deceased.
So, again, I made my offer. I didn't think I should have to, but I did. If the court is indicating that we cannot present that portion of our defense, at least it'll be on the record. But I'm indicating that we would intend to put on evidence of where he was found, that he was taken to the hospital. And then there's also the fact, which I would then, once we presented that, there is the suicide note where he exonerates Mr. Troconis. I recognize that it doesn't come in under as a statement in contemplation of death. In other words, not a dying declaration, but I would attempt to present sufficient evidence that it would come in under the residual hearsay exception, that there's no other way to get that statement in. The court may, at that point, in its discretion, determine it doesn't meet that, but I have to put on the evidence in order to reach that point. Again, for the first time in this case, only the defense is being
Counsel, you
required.
did not repeat that. The court was not aware of what the defense counsel was attempting to do. It was simply the fact that Fotis Dulos is deceased. The court would not allow that testimony because it's not relevant. The fact that Fotis Dulos...
Unlike the prosecution, this one doesn't make a whole lot of sense. I don't know why you're bringing up why Fotis Dulos is dead. Other than he left the note. I think he's trying to get the note in, but that's... I don't know. This is not the best. I understand they're working with what they got, so... Yes, the contempt hearing will be conducted after everything's done. So... it'll be conducted, and then he'll wait to see what happens with the verdict as far as just determinations. So
essentially wanted to exculpate the defendant is another matter.
If I may be heard on that, Your Honor,
Well, that's going to be a matter that comes up at the time.
that's fine. Thank you.
Again, if the matter was simply Fotis Dulos is deceased, court would not allow it. Which witness is the defense prepared to call at this time?
Robert Haynes, Your Honor.
You can bring the jury in, please. So would you raise your right hand, please?
Judge, the
The jury isn't in yet.
Counsel stipulate, please.
Yes, Your Honor.
Yeah.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Robert Haynes, ROBERTHAINES.
Thank you, sir. You may be seated.
Thank you. Good morning, Mr. Haynes.
Hi.
You go by another name. I know your formal name is Robert Haynes, but can you tell the jury what you're often referred to as?
Yeah, Hutch. Hutch would be great.
And you're here pursuant to a subpoena, correct?
Correct.
You and I haven't spoken until about a day ago?
Nope.
And you're familiar with Michelle Troconis?
Yes.
You haven't spoken to Michelle Troconis since 2019?
No.
Do you own a property with a lake or pond on it?
Yes.
Can you tell the jury a little bit about that property and where it is?
We have a water ski pond in Avon, Connecticut. It's a private membership. We're all very serious water skiers. You would join the
Little
club,
serious.
and it's really kind of a community. It's a very small community. We all pretty much are there most days, and we are tournament skiers, so we practice during the week, and a lot of times some of us will be competing on the weekends and traveling, and there's about 30 members, and it's a big family.
I'm going to ask you a few questions just about the pond and the area. You call it a pond. In terms of compared to other water ski areas, is it a relatively small pond or a large one?
It is small. No, it's very small. A lot of people will ski in open lakes. This pond is about 1,600 feet long and maybe 300 feet wide. So it's not a pond where you can go off and just really ski and go for long runs. It's a competitive site where you're either in a slalom course or you're on a jump, or some people will trick ski. So it's a 3-event competitive lake versus like an open water lake.
Are you-
Very small.
Are you familiar with the term short setup?
Short setup, yeah. So the short setup is in most places or most lakes, you can get up behind the boat. This is referring to slalom skiing. You get up behind the boat, you have a minute or two to adjust your shorts or whatever, and then you're in the course. You go through gates around 6 days, and then you drop it into the lake. Our lake is incredibly short in that you get up and you don't have time to do anything. You are immediately in the gates. You go through the 6 buoys, and then you're in the water again. So you literally come up behind the boat. You ski for 16 seconds, and then you drop down, and then you do it again. So you're not even skiing for a minute.
And this property, that you own this property?
Yes.
Is it private property?
It is.
How long have you had the ski club?
We've been skiing there for about 45 years, I would say. I'm 58. I started skiing there when I was about 10. The club itself is probably, I don't know, 25, maybe a little bit more, 25 years old.
And is the pond open year round?
No,
Can you tell the jury a little bit about how the season works, when it starts and when it ends?
it's very weather dependent, but the earliest we could possibly open would be the end of March if weather cooperated. We have some really serious skiers in our club that will put on heavy wetsuits and ski in very, very cold water. So they might get started at the end of March. Typically we wouldn't really start skiing until May, and we would ski always through September and a lot of times to the end of October.
And during that period of time when you're open during ski season, is it throughout the week? Is it Monday through Sunday or just on weekends?
It's every day. So it's every single day. There's people there all the time. With 30 members, there's a lot of people in our club that might find odd times to ski when they know there's not a crowd there, because if you go on a Wednesday at 5 o'clock when people get out of work, there might be 10 people waiting to ski, and that could be an hour and a half or 2 hour wait.
Is it more crowded on the weekends?
It's more crowded on the weekends, but on the weekends everybody has all day, so they can hang out and not. You're losing daylight on a Wednesday, so we may only be able to ski till 8 o'clock at night. So from 5 to 8, everybody's trying to get their ski set in. On a weekend, there may actually be more people there, but you have all day to ski, so nobody's worried about getting their time in.
Would people make reservations to be able to ski, or would they just come down and show up?
Pretty much, they would just come down and show up. So yeah,
And while people were waiting to be pulled on the skis or to ride the boat, would they often hang out? Is there an area for people to hang out?
so we have a very large dock, and we do have like a picnic area with a tent over it, and we have a couple areas to hang out. But yeah, everybody would socialize in one place or another, and you're waiting. You could be waiting 2 hours to ski, so you're there. You're there just kind of hanging out. You get in and out of the boat. You take turns driving a boat. You take turns riding, because you always need a driver and you need somebody riding. So you're working ski lines and, all that kind of thing. So it's busy. Everybody has kind of something to do. But at the same time, these guys, the people that are in the club, most of the people have been members there from the beginning. So it's a family. You're hanging out, talking to them, and, a lot of times talking smack.
And would people bring dinner or lunch down
Sure.
there sometimes?
Yep.
And when you say people had been there mostly from the beginning, are you familiar with Fotis Dulos?
Yes.
Was he a member of the ski club?
Yes.
Do you remember when he joined the ski club?
I can't tell you exactly what year, but I'm going to say it was 2005, maybe. I know he moved to Connecticut with his first wife and joined our club. And I gotta say it's 20 years ago.
Do you know the name of his first wife?
Hillary.
Had you met Fotis Dulos prior to 2005?
Yes, I've known him. He was a water skier, so I've known him, through water skiing, probably 10 years prior to that.
So since about 1995?
Probably, yeah. So the first time I spent any time with Fotis was when I got married. Boy, don't ask me for a date because my wife's out there. I'm gonna get in a lot of trouble. But we flew to Greece on our honeymoon, and I had Fotis's name, and we met Fotis one day, and he showed us around. Our honeymoon was in Greece, and he showed us around Greece. That was really the first time I ever spent any time with him.
And was Fotis a competitive water skier?
Yes.
Were you also a competitive water skier?
Yes.
Did you see him at water ski tournaments,
Yeah, definitely.
in state as well as out of state?
Yes,
Do you know whether Fotis often traveled out of state for competitive water ski tournaments?
he did. He was in his younger years. He was on the Greek team, so he water skied for Greece. So those are European tournaments. And then he would ski tournaments all around the country in the U.S.
Did you also come to know Fotis's children?
Yeah.
Do you know whether they water skied?
They did.
Do you know whether they traveled out of the state for competitive water ski tournaments?
They did all the time.
And was that with Fotis?
Yes.
Had you in fact seen them out of the state at competitive water ski tournaments?
Yes.
Had you had the opportunity to observe Fotis at the water ski club with his children?
Yes.
Can you tell the jury a little bit about whether or not they water skied together and for the amount of time that they may have stayed at the club, not as to what was said, but just your observations? And to narrow down to a certain time period, I'll say between 2015 to 2019.
So
I'm going to object, Your Honor. This is irrelevant. It's a vague question. It's
Not relevant, counsel.
Just as observations and awareness of Fotis during that time and what he observed.
Not relevant to saying.
Did you know Jennifer Dulos?
yes.
Did Jennifer water ski?
No.
Did she hang out at the pond ever?
objection. The time frame, vague.
Any-
Well, the question is ever. So overruled.
You can answer.
Rarely. She would come down. So her kids would be, most of the time, her kids would come to the pond with a nanny, and they would ski with Fotis, and the nanny would be on shore taking care of them. It's not that Jennifer was never there. She was there every once in a while, but she wasn't there most of the time when the kids were there. It was always a nanny.
Prior to 2017, did you ever socialize with Fotis and Jennifer?
Objection.
Ground.
Relevance 2017, prior to 2017.
Relevant, counsel.
Your Honor, I'm getting into Mr. Haynes's knowledge of the time period when Mr. Troconis moved into the house and Ms. Dulos moved out of the house. That's going to be my next question.
Well, the objection is sustained.
Did there come a time in 2017 when, do you know where Fotis Dulos lived in 2017?
Jefferson Crossing, right? Yes.
Is that where
Yes.
Mr. Dulos lived at the time? Did there come a time when Ms. Dulos no longer lived at Jefferson Crossing?
Objection.
Well, what's the ground, please?
Relevance, it calls for speculation.
Well, if there was a friendship, it would not call for speculation, so overruled.
You can answer the question.
I don't recall him ever. Well, he was a builder, so he lived in a lot of homes, but I don't, in that time frame, I don't remember him moving out of that house.
Do you recall whether Jennifer moved out of the house in
Yes.
2017? Did there come a time when you met Michelle Troconis?
I met Michelle very briefly at a water ski tournament in Florida. Fotis had his kids down there. I had my kids down there, and I was briefly introduced to her. I thought it had to have been 2016, maybe.
So prior to 2017,
Yeah.
recall meeting Mr. Troconis?
Maybe 2017. Yeah.
Do you know if Michelle Troconis moved up to Connecticut?
Yes, she did.
And do you know when that was?
There's definitely a long gap after after I first met her. I feel like it was probably a year or maybe 2 years after that. Don't hold me to the time frame, but I know she moved up a little bit. A ways after my first encounter with her.
Did around that time period, did Fotis ever talk about an intention that he moved Michelle up here?
Yes, he talked about it, about having a girlfriend, and eventually he was going to get her up here. Yes.
Did Michelle ever join the ski club?
Yes.
Do you know when she joined the ski club?
I think it was 2017. It was 2000. It was either 2017 or 2018, but she was a member.
Would you see Michelle at the pond frequently in 2017?
Yes.
Would you speak with Michelle when she was at the pond?
Yes.
And you said that at the pond there were sometimes social events?
Yeah, not planned, but there was so many of us around all the time that, regularly, there were summers where we eat dinner down there every night, and there's always other people around. So whether it's simple as getting a pizza or doing something a little bit more where everybody's bringing something, yeah, we had, social gatherings all the time. It wasn't a planned gathering. Everybody would ski and then just hang out.
So between 2017 until early 2019, had Michelle and Fotis attended some of these social gatherings?
Sure.
And had you socialized with Michelle and Fotis outside of the pond on occasion?
Yes.
You had told the jury that Fotis had water skied with the children at the pond. Did there ever come a time when Fotis was unable to ski with the children at the pond?
Objection.
Ground.
Calls for relevance, calls for speculation, hearsay.
Well, court is not clear on the relevance.
Your Honor, I'm going to link it. It's subject to connection. If I can ask a few follow-up questions, I'm going to establish Mr. Dulos's behavior related to the custody and visitation.
Well, there's no foundation.
Not going to work.
For questions about custody and visitation with this witness.
I need to ask some foundational questions, Your Honor, related
You
to
can
that.
ask the direct question.
Did there come a time when you learned that Fotis could not see his children?
Objection, calls for hearsay.
Well, overruled.
I remember a point where, and I felt like it was sudden because I wasn't completely knowledgeable on everything that was going on, but I remember that Jennifer at one time left the home, and I believe she took her children with her.
Do you remember, without getting into what was said, Fotis's demeanor or emotion or attitude towards not being able to see his children?
Objection.
Overruled.
Oh, he was upset. He was very upset. I mean, those children were his life.
I'm going to fast forward now to 2019, prior to the ski season getting into full swing. Did Fotis ever express to you an immediate expectation that he would be skiing with the kids at the pond again,
Yes.
and that he was expecting to be able to take the kids to compete in water skiing again?
Objection, Your Honor, this all calls for hearsay,
Expectation of immediate future conduct.
which he would say and express, which is a hearsay statement.
Well, at this point, the question is the question, did Fotis Dulos talk to this witness about his expectation? Is that the question?
Yes, Your Honor.
And if I may, Your Honor, when, what time, and again, it's a hearsay statement about what he is expressing his statement at a specific time.
I can rephrase that, Your Honor. In early 2019, did Fotis express an intention to be competing with his children again?
Object, is that January? Is that February? Object on time, it's
Well,
vague
the question
question.
is in 2019. So the court is going to overrule the objection.
You can answer that.
He was expecting to get his kids back into skiing and being able to spend more time at the pond and skiing with them again. He did not mention competitions.
Do you recall when in 2019 that was?
That was that Thursday night.
And when you say that Thursday night, was that May 23rd, 2019?
Yes.
Can you tell the jury about his demeanor or attitude towards that expectation?
I mean, it was when Fotis and I talk, 90% of our conversation is water skiing. We never did business together, really. We never had any outside life other than water skiing. He was definitely devastated when he didn't have his kids skiing. So I think he was excited that he was making progress, and he felt like he was making progress. And he definitely said he thought he would have them at the pond a lot more. Prior years, he didn't have them down there at all. And I think he thought he was going to be able to get shared custody and be able to spend weekends with them skiing, and even, sometimes during the week. I think that's what he was hoping for.
Okay, and that was around May 23rd, 2019. I want to talk about May 23rd, 2019, because, well, can you tell the jury if you saw Fotis Dulos on May 23rd, 2019?
I did.
Can you tell the jury a little bit about those circumstances?
Dinner. We were invited to his house for, I wouldn't call it a dinner party, there was 6 of us, just a gathering, nothing formal.
The
It
Jennifer.
wasn't last minute. We probably talked about it a couple days earlier. And we met him, we went over to their house for dinner.
Who were the 6 people who were in attendance is this Fort Jefferson?
Yes.
Who were in attendance at Fort Jefferson on May 23rd, 2019?
My wife and I, the local realtor, Stefan, and his wife, Beth, and Michelle and Fotis.
And your wife's name is?
Erin.
Do you remember what time you got there that night?
Honestly, I don't. I think it was somewhere around 6:30, my guess.
Do you remember what you ate for dinner?
I'm pretty sure it was chicken. It was a Greek salad, maybe French fries. We definitely had a bottle of wine.
Do you remember Fotis stepping out at any point in time in the evening?
I do not.
When you saw Fotis that night on May 23rd, 2019, do you recall whether his hair was short or long?
I think it was short.
And had you ever seen him before in previous years with a very short haircut?
Sure.
And did people at the ski club often have short haircuts?
Yeah, we have a couple members in our ski club who would shave their head, not shave their head, but definitely cut it way back for the summer.
Were you surprised at all about his haircut?
Not really. It was, going from long to short is always a different look, but I wasn't surprised. I didn't think anything of it.
And was anything unusual about that dinner?
No.
Even looking back in hindsight, was there anything unusual about that
No.
dinner? You talked a little bit about Fotis's mood. Did he seem happy?
Yeah, it was just, happy. He was very friendly. We hung out. It was very relaxed. There was nothing odd about it whatsoever.
Even now looking back, all those
Even now looking back.
in hindsight.
Yes.
Do you know do you recall time you left that evening?
I'm guessing it was somewhere close to 10 o'clock.
Do you know whether you left before or after, you said Stefan and Beth?
I feel like I left before they did. And the reason I think that is because I remember walking out and seeing a nice car in the driveway and saying, real estate must be good.
Is Stefan in real estate?
Yes.
Okay. Do you recall leaving of your own accord, or was anybody wrapping up the dinner?
No, I think, no.
After you left, so that's May 23rd, 2019, did Erin leave her purse at the house?
Yes.
Can you tell the jury a little bit about the circumstances surrounding how you found that out and what happened next?
we drove home, and I think when we got home, Erin realized that she had forgotten her purse, and instead of, she wasn't overly worried about it. Instead of, it wasn't like at a restaurant, it was in somebody's house. And I don't remember whether she, I feel like she may have texted Michelle that night and said, I forgot the purse. It might have been the next morning. She may have been the next morning. I don't remember.
And how did the purse was the purse eventually returned to your wife?
They had texted between themselves and arranged to have Michelle drop it off in my office, which she came by and handed me the purse.
Do you know, when you say she came by the office, is that at the pond?
Yeah, it's in front of the pond. I own a business there, a self-storage facility with an office up front. So it was my place of work. So I was working and she just walked in and handed the purse.
All right. Do you know if she handed the purse directly to you?
She did.
Okay. Do you recall talking to her at all when she came?
It was very brief. I feel like she was going to the grocery store, mentioned on my way to the grocery store, but it was a 10-second conversation, not even.
Was there anything unusual about her demeanor at the time?
No.
Even looking back in hindsight?
No.
So that weekend, that was Memorial Day weekend, at some point, you learned that Jennifer was missing.
Mhm.
And at any point in time that weekend, did Michelle or Fotis come to the ski club?
We did not see them Saturday, but I saw Michelle at the pond pretty much all day on that Sunday. I believe Fotis was going to see his kids or try to see his kids Sunday, so he was not there. Michelle spent the day at the pond with her daughter, and then Fotis, I think later, probably late afternoon, early evening, showed up at the pond.
And can you tell the jury a little bit about what Michelle's demeanor was like on that Sunday at the pond?
So I believe there was state police at her house. I don't know whether they were in the house or parked out in front, but I know she didn't want to be there. So she was obviously agitated. I remember she tried to ski. I mean, the water was still very cold, but she was upset and she was definitely teary-eyed.
And you said Fotis came later in the evening?
Yep, Fotis, I don't think he was able to see his kids, so I think he ended up back at our place or back at the pond. I would say sometime, it was later, maybe 5:30, 6 o'clock.
Did Fotis, when he came, seem upset or concerned?
He was upset that he didn't see his kids for sure. Yeah, he was upset.
But that was your impression that that's what he was upset
I feel like
about?
he was upset that he wasn't able to see his kids.
During that weekend and the days that followed, was there a lot of media presence at the pond?
Yes, it was unbelievable.
Was there a police presence at the pond?
There was heavy ething at the pond. So we had, I mean, it was nonstop. So yeah, podcasters calling, you have reporters driving in, calling, the state police, showing up at my office to look at surveillance. Our pond it's sacred ground to us. We have 30 people in our club that love that place. And the state police come in with dogs and they search the place with dogs. And then they put a boat in the water and they go over the whole pond with a boat looking for a body.
They messed with our sacred water,
And it obviously still is up.
our precious fluids. They violated our fluids, chat. It was heckin' bad. Thank God. Damn.
Upsetting for you.
Yeah, no, it was probably one of the most painful times of my life.
And they searched your property pretty thoroughly.
Yep, I gave, the state police came down early in the week and I gave a tour and showed somebody and told them all about the pond. And then I feel like it was a couple days later, they got a search warrant and they came down with dogs and taped off the whole place. And there had been 20 police officers just doing their searching the whole place. And then I don't know if it was a couple weeks later or it was when it was, but they came and did it again, this time with a boat, put a boat in the water.
And you cooperated fully with that?
Absolutely.
Did you speak to Fotis around that time?
The only real contact, I mean, around, so yeah, I mean, during that week, no, I didn't see him at all.
In May of 2019, do you remember Fotis ever saying something to you about Jennifer having left in the past and he expected that she would show
Objection.
up? Effect on the hearer listener, Your Honor.
Then it's irrelevant.
This is not going to be a street corner argument. The court knows of no exception to the hearsay rule effect on the hearer. In this court's view, that's folklore. That's not the law. An existing emotional or mental condition is an exception to the hearsay rule. This is not being offered, as the court understands it, for the truth of the matter is overruled.
You can answer that question.
So Fotis would look at me and over the few times I saw him, he would say, I did not do this. I did not do this. And he did at one time tell me that Jennifer had run away at some point earlier in her life, and I don't know the details of it. And he said she's doing it again.
Have one more, please, Your Honor. I have no further questions. Thank you.
Cross-examination, please.
Thank you. Good afternoon, sir. How are you?
Good.
My name is Michelle Manning. I represent the state. And ask you a couple questions, okay? Okay. Now, briefly, you talked a lot about on direct about you on the pond.
Yes,
Okay, and that's what the ski club. What is the ski club called?
Old Farm Skiers.
And it's members only.
Yes,
Okay. And Fotis Dulos was part of that water ski membership.
yes,
correct? Okay, and Michelle Troconis was as well.
yes,
Now, you also own the storage facility that's around that pond.
yes.
Okay.
Did-
And with respect to water skiing's important to you, correct?
Yes,
Yeah, you've been doing it a very, very long time,
Yes.
correct? Okay. So, I mean, you own a pond, I think you described everybody as a community, would you
Yes.
say? Okay. And Michelle Troconis was part of that community, wasn't she?
yes,
And in fact, you talk about many times that you would just hang out on the dock, maybe have dinner together, things like that. Is that correct?
yes.
And you would talk to her a lot during the time she was there, correct? You socialized
We'd socialize, but in a group.
in a group?
Yeah,
Yeah.
and, like,
In English?
yes,
And I want to ask you some specific questions about the party on May 23rd. It was planned a couple days in advance. That was your testimony,
I
correct?
think so, yes.
Okay. And you've had, you didn't know that Stefan Reich and Beth Johnson were going to be there that day in advance, did you?
I feel like I did.
You feel like you did?
Yeah, I think there was going to be 6 of us, yes.
Okay. Was Stefan Reich part of the water ski club?
No.
Okay. Beth Johnson wasn't either.
That was, honestly, that was the first time we met them.
That was the first meeting that night. Okay. And you were invited by Fotis Dulos?
Yes.
Okay. And you got there, I think you testified around 6:30?
I'm guessing, I don't know. I just don't remember exactly what time.
It's been about 5 years, you would say? Is that fair to say?
Yep, yes,
Okay. And when this first happened, there's a lot of media attention?
Yes.
I think you talked a little bit about it. You mentioned this was a very difficult, I think your words were, this was the hardest thing that you've ever gone through in your life?
yes,
Was the media attention?
Mhm.
Okay. By the way, you see the camera behind me?
yes.
And have you been watching on TV?
No, haven't seen a single second of it.
Okay, but have you noticed the news reports?
No, I won't watch it.
You won't watch it at all, right? Because you're very close to Fotis.
Yep.
Okay,
Well-
it's very, very big part of your life. I think you said 30 years.
Yes,
Now, at the dinner party that night, the kind of impromptu dinner party, you'd say, right? It wasn't very formal.
no,
Okay. It was you, your wife?
yes,
Okay. And Stefan Reich, correct?
yes,
Beth, I think she was Johnson at the time. Yep. And Michelle Troconis and Fotis Dulos, correct?
Right.
Okay. And I think you
We'll get to
testified
this in a
that there
second
was
on-
nothing odd about it. Those were your words, correct?
that's correct.
Okay. But Fotis talked about the fact that he really couldn't wait to get that. He had an expectation he was going to get the kids again, right? Is that correct?
Yes,
And he talked about, I think you testified, you talked about the fact that, on May 23rd, he was excited. He was going to take the kids water skiing again. I think that's what you said too. Right?
yes, he said he was making progress where never before has he been making progress to get them, to
Never?
get custody, to get visitation.
Never before? You remember him saying that?
Repeat that?
You said he's been making progress where never before
Well, up to that point, I don't think he really had the kids at all.
Okay.
And not even, I mean, he would be able to see them once in a while, but it wasn't very consistent.
And on May 23rd,
He mentioned that he thought he would be able to get more visitation and that we might be seeing the kids at the pond where we haven't in a long time.
Did you discuss the plans to murder Jennifer the next morning at the dinner party?
Say that again?
Did you discuss the plans did Fotis Dulos discuss and Michelle Troconis discuss the plans to murder Jennifer at the dinner party on the 23rd?
No,
Did they discuss with you at the dinner party to dispose of evidence of the murder as a garbage cans of Albany
Objection.
Avenue?
no.
Brown.
Argumentative.
Well, the question is essentially, the leading question is, was the intent to murder Jennifer Dulos discussed at the dinner party? And your objection is argumentative. Well, the clear answer from this witness is going to be no. So the objection's overruled.
Did you have those discussions, sir?
No.
And what about the plan to use the Tacoma and clean it afterwards? Did he discuss that?
To what?
To use a Toyota Tacoma and then clean it afterwards? Did he discuss that with you?
No.
And you talked a lot about the media influence on the pond and how the police coming with, I think, did you say they searched the pond one day and then they came back with a boat and divers? Did they do that? Okay. And that was the worst experience of your life, them searching for?
It was an awful experience. It was an awful experience.
Yes, awful experience searching.
The whole thing's an awful experience.
Of
Yes.
course. You watching the pond being searched for a dead body of a mother of 5 was awful for you. We understand
Objection,
that.
Your Honor.
Sustained.
And nothing further, Your Honor.
I have a few follow-up questions.
Yes.
The state had asked you about speaking to Michelle Troconis, and she spoke English, correct?
That's correct.
Did she sometimes struggle to find the right words?
Sometimes.
And she would ask what certain things meant?
Yes.
And the state had asked you about Fotis's communications about making progress. Were you aware at the time that custody report had come out?
Objection.
Sustained.
Did Fotis talk specifically about court proceedings in terms of making progress?
Objection.
Well, did he talk about it? The answer is either yes or no. The witness does not remember, so that's overruled.
Do you want me to re-ask that?
Yeah.
When you had mentioned that Fotis Dulos was talking about making progress, was that in the context of the custody proceedings in court?
Yes.
And the state asked you some questions if you were part of some plan to do something nefarious, and you had said no.
No.
You've known Fotis for decades,
Yes.
right? And even in hindsight, looking back, there was nothing to alert you to the fact at the time, right?
No.
Nothing at all?
No.
No further questions.
Nothing further. Thank you.
Mr. Haynes, you may step down. Is there another defense witness available at this time?
Yes, we won't get done with that witness, but we can certainly start unless the court wishes. I figure we should start. Yeah. And I've had Attorney Felsen is, I think, bringing him in at this point. Do you want to switch back? Or?
Do you solemnly swear or solemnly and sincerely affirm this case may be that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth? So help you God or upon penalty of perjury?
I do.
Can you please state your name and spell it for the record?
Stephen Reich, Stephenreich.
You may be seated. Thank you.
Thank you.
Good afternoon, Mr. Wright.
Good afternoon.
Would you please indicate to the members of the jury what you do for a living?
I'm a real estate agent with Coldwell Banker in Avon, Connecticut.
Where do you live?
Avon, Connecticut.
With whom?
My fiance, Beth Reich,
How long have you been a real estate agent?
since 2009.
Can you tell the jury a little bit about what kind of real estate, there's different kinds of real estate agents, right?
Yeah, you have commercial, residential. Yep. So I worked primarily residential, new construction, land acquisition for building, luxury properties, and that's most of what it was.
What area, is it mostly in Connecticut?
Yes, mostly the Farmington Valley of Connecticut. So Avon, Farmington, Simsbury, West Hartford,
Can you tell me whether or not you knew Fotis Dulos?
I did, yes.
Did you know Michelle Troconis?
I did, yes.
How did you get to know Fotis Dulos?
Actually met Jennifer while she was walking the first set of twins, Petros and Theodore, at the development they lived in Caanan in Griswold Farms. I lived there as well. I met Jennifer while walking the dog a few times and seeing her around the neighborhood.
And for the record, when you say Jennifer, who are we talking about? What's the full name?
Jennifer Dulos, Jennifer Farber Dulos.
And at the time you met Jennifer Dulos, was she married to Fotis Dulos?
Yes, she was.
Did you become, could you just tell us whether or not you had a friendly or unfriendly relationship with the Duloses back then when you met Jennifer?
No, very, very friendly.
Can you just describe briefly, you said you met Jennifer when she was walking her twins in a stroller?
In a stroller.
Could you just describe in a little bit, did you have a conversation to see her? What did you do?
I saw her, we just, started a conversation, they were new to the neighborhood, I was new to the neighborhood, I moved from New York, we just, kind of hit it off, just having general conversation. I had seen her subsequently a few times while she was, she would walk the babies in the strollers quite often, and she had suggested that we come over to their house with my ex-wife at the time to just have a drink and get to know each other.
And did you do that?
Yes, we did.
Approximately what year was that, if you recall?
I would say probably 2008,
How far away did you live from the Duloses back then?
less than a half a mile.
Was it the same neighborhood or
It was-
just on the same road?
The same subdivision, same neighborhood. We were on one street, they were on the next street over, down the road.
Did you also develop a social relationship with Fotis Dulos other than just going there once for drink?
Yes.
How would you describe the relationship as it developed over the next few years?
The relationship between whom?
Between maybe I should separate them. Between you and Jennifer Dulos and you and Fotis Dulos during that time.
We had gone out to dinner several times. I mean, we just, would mostly go out to dinner and socialize.
I don't disagree with you, Brad.
We'd always talk, and I was transitioning work-wise from a family business, and Fotis had suggested that, I possibly get my real estate license and do sales and marketing for his company.
Did you go into real estate and get your license because of Fotis Dulos' suggestion?
I did, yes.
Could you tell us what was the employment of Mr. Dulos at that time when he made that suggestion to you?
What did Fotis do for a living? Is
Yes.
that the question?
Yeah.
He owned a company called Ford Group, which was, a higher-end luxury home builder in the Farmington Valley.
And when you got your real estate license, did you have any professional dealings with the Ford Group?
Once I got the license, I obtained all of the listings that the Ford Group had.
And would that indicate that you had income from and through the Ford Group?
Correct.
During that
exclusively.
time frame, did you continue to maintain a social relationship with both Jennifer Dulos and Fotis Dulos?
Yes.
Do you water ski?
I am not a water skier. I snow ski, but I have water skied with them, I think maybe 3 times, but that's just not really my thing.
So when you say with them, did Jennifer Dulos during that time frame water ski?
I water skied at the pond, I believe, 2 times with Fotis at the pond in Avon, and then I did water ski with Fotis and Jennifer in Greece when we were there for Clay and Noel's baptism.
So do you know what year that baptism would have been of Noel? She was the youngest daughter, correct?
She was the youngest one, yes.
Do you remember approximately what year that
I
was?
don't remember the exact year.
What were the circumstances of you being in Greece at the same time as the Duloses back then?
They invited us to go there for the baby's christening and to have a vacation.
Where were you water skiing with the two of them?
I don't know. It was an area where Fotis had skied kind of growing up, and we skied with some friends of his, and Jennifer was on the boat and she skied as well.
Do you recall whether or not Fotis Dulos was involved in any competitive water skiing activities during that time where he'd actually compete?
He was, yes.
Did you ever observe or go to I don't know if it's called a tournament or a meet?
I don't believe I've been to a competition. I mean, I have seen him ski at the pond, a couple times, but I don't know if that was a competition per se.
Did you ever observe any medals or ribbons or any other certificates he got in his competitions?
Yes, I've seen that.
Where did you see them?
Probably Facebook post or, after an event, he would tell us how he did.
You have how many children?
I have one child, one biological child.
Was your child of similar age to any of the Dulos children?
My child was the same age as the second set of twins,
And for the record, how old is your child now?
15.
Did your child go to school with any of the Dulos children?
Yes,
Where was that?
the Farmington Valley Academy, Montessori, and Avon.
Did there come a point when the Duloses moved from your neighborhood to another neighborhood?
Yes.
Do you recall when that was?
I don't remember the exact date now.
Were you at the time working for a real estate company, or were you on your own?
No, working for a real estate company. I started with William Ravis from when I got my license, I think 2009 to 2017, and then I've been with Coldwell Banker since.
Did there come a separate time when you went to work for the Ford Group as an employee?
That is correct. I still maintained my real estate license, but I was not a 1099 with Ford Group. At one point, I was a salaried employee.
When you say 1099, if you're a real estate agent, how do you earn money if you're selling property through that's being built by a builder?
You're earning commissions, and then you're getting a 1099 from the broker at the end of the year.
Tell the jury about your employment at Ford Group, where you actually were you were salaried?
Correct.
Could you just tell the jury how that came about?
Fotis did not like the fact that I was earning a lot of money in commission on the sale of some of the property. So he wanted to bring everybody in-house and then kind of share in, some of the commission
Just wanted
proceeds.
to wet his
So,
beak on the
I kind of
profits.
still did the same thing, but my role was maybe expanded to do more, sales and marketing for the company and working with architects, down in the Fairfield County area to try to have Ford Group included in bids for custom homes.
You said you didn't like that you were earning so much money. During this time period, what was the usual commission that you would earn for the sale of a home?
It depends. It's a percentage of the sale of the home, but it was more not outside of Ford Group, but the homes that Ford Group sold, some of them were millions of dollars, and the commission numbers added up, and Ford Group didn't participate in that money. That money came to me. I believe I earned it. I worked hard to sell those properties.
Right. But if the real estate commission was based on the price that the house sold, is that correct?
Correct.
You would earn more money if the house was more expensive.
Correct.
Did the Ford Group tend to build expensive homes?
Yes.
How long or what years did you work as an employee for the Ford Group?
I believe 2014, sometime in the year till probably January 2017.
During the time you worked there, what was your actual responsibility and job?
Sales and marketing of the existing homes that we had, maybe speculative homes, marketing of homes that were, quote, to be built. Well, these were paper listings that we would sell a land build package to a potential client. I'd help out with renovations that the Ford Group was doing, land acquisition, working with the municipalities to subdivide land, so working with the town, working with planning and zoning, whatever was needed.
Was there a difference between a custom-built home and a speculative home, as you just put it?
Yes, a custom home is a home we're building for a specific customer that, they've given deposits and it's their home, versus a speculative home where the company, Ford Group, is putting up the money in hopes of selling it as quickly as possible, preferably during the time of construction so that the carry costs would be minimal to the company.
During the time that speculative homes were being built, what was your role while you were an employee?
Well, there were speculative homes, custom homes, like the role never changed regardless of, what homes are being built.
I see. Did you meet with prospective buyers yourself during that time?
I did, yes. Not by myself, but mostly with Fotis together, Fotis and I.
Do you know when you stopped working for the Ford Group?
I believe it was end of December, January 2017.
Well, end of December of 2017 or the end of?
No, it was either the December 2016, January 2017.
Could you indicate to the jury, what were the circumstances for you leaving the Ford Group?
He terminated me.
Can you tell them why?
He wanted all the employees to sign a non-compete agreement, and the non-compete agreement was it was just beyond the pale of what it should be. It was incredibly restrictive.
Maybe the jurors know what it is, but maybe you can just explain what a non-compete agreement is or was in your case.
It basically said, I'm an at-will employee, so Fortis can terminate me at any point. And if I would have signed the non-compete, the way it was written, it basically prevented me from being a realtor. It prevented me from using any subcontractor the Ford Group used. It prevented me from using any architect that Ford Group used, and it prevented me from contacting any client. And a lot of those clients were my clients that I brought to the Ford Group. So it was just, I heard it was not enforceable because of the language, but out of principle, I just was not prepared to sign it.
And how did you find out you were being terminated?
Fotis wanted everybody to sign it. He said, if you don't sign it by Monday, don't show up for work. And I didn't show up for work.
Did it change your relationship with Mr. Dulos for you to be terminated under those circumstances?
It certainly did. It certainly changed, the business component of it, because I lost a lot of the listings, not all of them. I think I had like one or two of the multiple ones that were out there. So yeah, it had an impact.
During the time just before you left or were told not to come in the December of 2016 or early January of 2017, were you still in touch with Jennifer Dulos?
I don't know if I was in touch with her. Most of the social interaction was when we were visiting with both of them together, like going out, or if they had an event at the house that we would go to. So I didn't see her on her own outside of Fotis. Yeah, maybe saw her at the grocery store or whatever, and give her a hug and a kiss and say hi, or see her at the school. But it was mostly the relationship was with both of them.
Did you continue to socialize with the Duloses while you were an employee?
While I was an employee, yes.
Including going out to dinner and showing up to events and
Yeah,
parties?
yeah. We went on vacations together. We went to dinner together. They had events at their house. We had an awards thing for home builders that we would go to every year.
How would you describe, while you were an employee, the relationship that you observed between Jennifer and Fotis Dulos?
It was positive. I mean, we'd go out to dinner. They would sit very closely together. They would always share an entree. But it seemed like it was a good relationship.
Did you become aware at one point that Jennifer had moved out?
I did.
And how did you find out about that?
I think Fotis told me. I don't remember exactly, but when she moved to New Canaan, I found out about it.
Did you have any reason to believe that that was going to occur before she moved out?
Can you repeat that?
Yes. Did you have any inkling that Jennifer Dulos had planned to move out before you found out she actually had?
No.
Did you have any contact with Jennifer Dulos after she moved to New Canaan?
I did after Hilliard died. I reached out to her to express my condolences because he was
After who died?
after her father Hilliard passed away.
And what was the nature? Just describe I don't need the substance, but how was that in terms of was it cordial?
Oh, yeah, it was very cordial. I just said, I'm so sorry for the loss of your father. He was a great man. He helped, the company very much. I've met him many times, and I thought he was an amazing person, and I was sorry.
And how long was that conversation?
I don't remember.
After you stopped working for the company, did you still have a business relationship?
I still had a business relationship. He gave most of the listings to a couple other agents in the area. And then over time, the listings started coming back to me.
Same kind of home, same kind of construction?
Yes, correct.
Same
Just
high-end?
under a different dynamic, that it was just, I'm representing him as a realtor. There was no other relationship, and that was it.
Back to getting a 1099 and a commission?
Correct, yeah.
Your Honor, I'm going to move on to another subject. Perhaps this might be a good place to break.
Thank you. Ladies and gentlemen, we will resume the session at 2 o'clock. Please do not discuss the case.
Am I free to go?
Okay, guys. I'm not going to lie, but I don't... I don't see this really helping her. Like, I don't get this guy's point. Am I wrong here, chat? Am I wrong? I don't see the value this guy brings to the probative value here. Like, what is he? Because it sounds like Fotis is a fucking dickhead. Okay, great. We already knew that. We already knew Fotis was a dick. Kimbo says he gave a look at the end like I can't believe an N-word's a judge. Well, see, that guy sounds a little Italian too, based on his accent, so he called him a mooly. He wouldn't say in the N-word. He would say a mooly, like a moulignon. Yeah, and he loves water skiing. Yeah, I get that too. Like, I've done the water skiing where you have like the bar next to the boat and you can do that. That's fun. But when you do it like with the you actually hold onto the rope, like I just get dragged. So, yeah. So, get an idea of Michelle's character? Maybe, I don't know. It's just like this isn't good. I don't think this is helping her. Also, real quick, a super chat to get to. Unhung Hero for $2 says, the contempt hearing, what did I miss? At some point, Michelle had access to a document on her laptop, on a laptop, and she was looking at it, and it was blown up really big, and it was a document from the child custody case with very sensitive personal information that she was portraying in such a way that people behind her, specifically her mother, Michelle's mother, could read it. And people from Jennifer's side saw it, and they told the prosecutor. So Michelle's in trouble because she's violating a court order. She's being accused of violating it, and the contempt hearing is going to happen after everything. So we'll find out what's going to happen there. Hubble says she threw fake license plates down a storm drain or something, right? Well, she threw a FedEx package down a drain, but it's not, it's still not exactly 100% clear how that all shakes out. So we'll wait how the prosecutor tries to show that. Now says good Fanny show last night. Yeah. Holy shit. Reading that document is hilarious, especially all caps, underlined, bolded. That speaks of lolcow territory. So, and I do think it's funny because people losing their mind on Twitter. It's like, well, how did they get that stuff without a warrant? It's like, they're not the government. They don't need a warrant. The warrants are for the government only. I could get all kinds of shit the government would need a warrant for. So, I don't know. Yeah. You see here, I don't know what you guys are thinking. That's kind of where I'm at with this. Never used the bar. Well, the bar is how you learn how to do it. Like, there's a bar sticking out on the edge of the boat that, like, there's an attachment. So it's like a big metal pole, and you can hold on to it. And that way it's easier because it doesn't, like, do anything. Vanny got McMahon, yeah. Steve says, did you get a warrant before reading through Fanny's response last night? No. Then enjoy prison, stalker child. Enjoy your prison with your warrants. Fanny loves polls, yeah. Especially polls at like 11 o'clock at night until about 3 o'clock in the morning. Riding the baloney pony with Wade. Sorry, guys. That was a little rough there. I'm trying to get my sneezing out of the way. Ooh-wee. Ugh. I guess not. Sorry. Okay, I think we're done now. Thank you. Bless you. Thank you, guys. I had a demon summon, yeah. God, I got another one coming, too. Well, so. But yeah, that's it for right now, guys. We will do part 2 this afternoon. We'll do part 2 this afternoon. What else we got tonight? We got a lot. I mean, so, like, we've got, so, day 25, part 2. The laundries. The laundries depot we're going to do for members here on YouTube. And then tomorrow, we could do like day 26 and 27 and finish it up, I think. So that's how the coup starts. Yeah. So, yes, there was a deposition for Brian Laundrie's parents because they're getting sued by Gabby Petito's parents for intentional infliction of emotional distress. And Brian Laundrie's dad's depo got released, and it's not flattering at all, but it's a really good read. It's a really good read. Only about half of it is relevant, so we'll start at that point where it's good. But yeah, it doesn't help them. It doesn't help them. Yes, Hella's stream is coming up 4 o'clock. I'm going to be joining her, and then yeah. We'll be talking about Mr. Franklin, the treehouse guy, and what lays ahead for him. And you thought they settled. Yes, they did settle. There's been a settlement reached between the Laundries and the Petitos, but we still need to cover it. I think it's still worthy to read the deposition. It's good to see how attorneys do things. It's also a civil setting. It's different than most of the things we ever watch. We only watch a lot of criminal stuff. So I think it's good to read it and understand what happened and what formed the basis probably of the settlement. I think it's got a lot of use there. So we'll take a look at that. And that's going to be later tonight. And that will be that'll be a members exclusive. Exclusively for the members. I found a model, Midwest Modeler RR, MidwestModelRR.com. This is a funny joke. I get it. It's a train thing, isn't it?
You're a funny guy, Sally. I like you. That's why I'm going to kill you last.
Just make sure. Maybe I'll lie about that, though. Maybe I'll kill you first. And then Future Mrs. Martin 2.0 says, hi, chat. Bye, chat. Yeah, she's been out and about, having fun, seeing people. So if you guys want a chance to see her, it's going to be very limited, but it's there. So I don't know what time we'll get done with Hella. I'll just go till I don't think there's a set time, so we're just going to go for a while. And then from there, we'll come back, and then we'll plow through it. Because, what's left for Michelle Troconis here? Day 25, it's just under 2 hours for day 25, the last part. Then day 26, we have a morning and afternoon, and then we have another morning for day 27, Friday. So it's all done. Friday is day 27 was Friday, so we'll be caught up, chat. And then on Monday, we have Hannah Reed, or as I watch Below Deck so much, the one chick, Hunter Reed. We're gonna be watching her all day, chat, all day. It's gonna be great. It's gonna be great. You promised to kill me last too. So I must be lying to somebody. Well, maybe I am. Yes, she's being social today. It's exhausting. Yes, it is. Oh, so all right, guys, that is it for now. We will see you guys back here in a little while. And work on part 2 later tonight, and then we'll do the thing for the laundries. So enjoy your. Hannah definitely committed defamation. Yes, Hannah definitely did commit defamation. I don't know how she's going to win that case. I think that's right. I mean, I haven't read the complaint at all. I don't know anything about the case, but she definitely committed defamation. That's going to be the default setting from now on, chat. Did that person commit defamation? Oh, and dang it, I forgot to do the Hannah Reed poll when I when I had the stream running yesterday. And it just says Hannah, yes, no. We're gonna have to put that up on Monday to let people watch it. Icon classes can't watch, has to train a new contractor. Okay, well, at least you'll be able to speed through spots. Yes, and Robert Lawrence is right. Hashtag GGPP. Gorilla Grip Pussy Pal. Although it's a Gorilla Grip Pussy Power, I think would make more sense. Tilly, how are you doing? So, all right, guys. Well, I'm going to sign off for now, and we will see you guys back. Oh, I don't know. A little bit later tonight, and we'll knock those out and then get into the laundries. So, take care, everybody. I'll be out rampaging through Indiana. Oof. Holy cow, hope they're ready for you. All right, guys, have a great day.